Yes,
May I
Mr.
please,
Dutta.
Your Lordship? My lord, I want to withdraw the case with liberty, item number 13, my lord. Partly allowed, my lord. We are getting my, I am getting my salary.
Where is the ticket? Certification? Certificate.
My prayer with respect to item
Liberty.
17, Lordship.
With liberty, my lord.
Complete.
Secondary.
No education?
Secondary education matter.
Okay. Yes, what liberty you want?
Liberty, my lord.
What
Only
liberty?
liberty because we have to file a petition, regularize the suspension period and benefit under ROP rule.
What was the case about?
For paying the regular salary, my lord. After the suspension of reinstatement, my lord, we are not getting. I have not getting in my salary, and
We'll
that
do
is
one
why.
thing. No, Mr. Dutta will pick up the matter. And after hearing the other side, liberty has to be given. Without hearing, it won't be possible. Yes.
Lordship, item number 12 for today's list. I am on instruction, I am allowed to withdraw this petition. While a person to entry order, they are getting the all.
Mr. N. Bora, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ.
Dear Lordship, I can appear, my lord.
For
Government. Elementary education is there.
you are appearing for whom?
Government of Assam, GS.
Okay, Ms. M.D. Bora appears on behalf of the government. Taking into account the state submission, the instant petition stands dismissed on withdrawal.
Lordship, I beg to mention item 17, Lordship. With the
Yeah.
due consent of the other side, Lordship, I need 2 weeks time to Lordship to get the appropriate instruction in this case, Lordship.
Why?
Lordship, whatever in this case, Lordship, they have preferred an application, Lordship, for correction of their age, Lordship. And the department is, Lordship, processing their Lordship application, Lordship, and within 2 weeks, Lordship, there is a probability, Lordship, they will, Lordship, issue a notification in this regard.
But Mr. N. Upadhyay, learned counsel appearing on behalf of the respondent irrigation department. He submits that the department is at present looking into the matter for which he seeks an accommodation for 2 weeks. That the matter be listed in the first week of May.
Lordship, oblige, Lordship.
Lord, again, it's supplementary motion, list Miller, item 58. Lordship, this is regarding payment of arrear salary, and Lordship instructed Miller to mention the matter at 2 p.m. So, let 2 p.m. make a
Agreed.
What do I recommend for item number 65? Item number 65.
55.
Lordship for upgradation.
Why?
Lordship matter relates to correction of order. And earlier proposition is the listed.
Correction of an order.
Right.
What happened?
Order of this. Order of this.
For correction.
Lordship.
We'll take it up as the first item. Wait.
Lordship, I beg to mention item number 7, my lord.
Item number 55.
I beg to mention item number 7, my lord.
Yes.
So in this case, my lord, I have missed the file, my lord, today. So it may not be taken up today at any day, my lord.
Item number 7.
7, my lord.
You are the petitioner.
Yes, my lord.
Your name?
H.
Oh,
Rahman.
H. Rahman. But Mr. H. Rahman, the learned counsel appearing on behalf of the petitioner. He submits that he needs an accommodation for 2 weeks. Let the matter be listed in the first week of May.
Oblige.
May I please, your lordship? Lordship, I beg to mention item number 35.
Yes.
Lordship, I am appearing on behalf of respondent number 4. We have filed additional affidavit. Lordship may call for records. Obliged.
Yes, so Lordship, I just mentioned item number 5. Lordship, as I've taken the consent from the other
Item number
item number 5.
5.
As I've taken the consent from the other side, so kindly please take the matter on 31st March on Friday.
Item number 5.
Yes.
No. 2016 matter, man. It doesn't look. We'll take it up. We'll see what can be helped. Tell your
Yes, please,
senior.
Your Lordship, Lordship, I beg to mention item number 52. We have already informed the other party and my senior is out of the. Item number 52.
You want it what? When do you want it?
Your Lordship, after 3-4 weeks
The request of the learned counsel for the petitioner,
for the respondent.
for the respondent. That the matter be listed after 4 weeks.
May I please, Your Lordship. My lord, for item number 49. My lord, this matter while issuing notice, my lord, Your Lordship be granted liberty to upgradation of it.
Update it.
Highly obliged, Your Lordship.
So, somebody? 49, na? Mr. Counsel? Yes,
sir. I pray for application item number 38, Lordship.
why?
Lordship, last occasion, the standing council were directed to obtain instruction as to when the payment will be made, Lordship.
Okay.
Item 38, develop.
Item 48, Lordship, there is liberty to enter for upgradation, Lord. Of like 48.
Yes, where is the correction? What correction you want?
Lordship, may I submit one thing, my lord?
Yes, just let me see what is the correction, then I will ask you. Yes. What is this correction you want?
Lordship, corrected order would be Lordship, petitioner to the post of foreman or junior engineer in the inland water.
Huh?
Earlier it was ordered by your Lordship, but mistakenly there is a typographical error. Earlier Lordship defective prayer was
I read in the nature of mandamus should not be issued directing the respondent to provide sanction of another post of eligibility.
Lordship. That's
Then what do you want?
we want Lordship petitioner to the post of foreman to promote the petitioner to the post of foreman or junior.
Just let me see that earlier application. IA 35. So it was, the same thing was repeated.
Lordship.
Yes. Pradeep.
Lordship, instead of correcting the prayer, the petitioner may withdraw this petition and file a fresh, Lordship, because it creates some problem. I have received instruction from earlier prayer, Lordship.
It's okay.
My lord,
It was a mistake committed by this court, will correct. Heard Mr.
LR Majumdar.
NR
Majumdar.
Majumdar, the learned counsel appearing on behalf of the petitioner, and Ms. M. Deborah, learned counsel appearing on behalf of the transport department. The instant interlocutory application has been filed, taking correction of the order dated 22/12/2022, wherein instead of mentioning, instead of substituting the prayer as a read in the nature of mandamus, shall not be issued directing the respondent authorities to promote the petitioner to the post of foreman or junior engineer in the inland water transport division, Silchar. It was the prayer which was originally there in the prayer A, which was originally there in the repetition, was again mentioned, taking into account that it was a mistake committed by this court. The order dated 22/12/2022 is corrected. And accordingly, the relief A would be read as a writ in the nature of mandamus shall not be issued, directing the respondent authorities to promote the petitioner to the post of foreman or junior engineer in Inland Water Transport Division, Silchar. That's all. The registry shall make the necessary correction. The registry shall make necessary correction in the in the accompanying writ petition. The instant order shall be a part of the order dated 22/12/2022 passed in IA Civil 3590/2020.
Obliged.
Yep, yep.
Item number 1.
You served it to the petition number 2. What is it? Your case?
Lordship petitioner was working as sales assistant in Assam Ayurvedic product under ASIBC Lordship. He was placed under suspension Lordship. Suspension order is at page 37.
Setting aside the suspension of the issued by respondent and to show cause why the respondent should not be directed to case of allowance.
My lord, I have received instruction, my lord. My lord, the thing is that, my lord, the inquiry has already started. And on 24th of this month, the petitioner appeared before the inquiry officer, my lord. So the matter is pending for a report from the inquiry officer, my lord.
Understood. What about
So, my
the
lord,
subsistence?
if some time is granted, my lord, then by that time the inquiry will be over.
Very well, I'll
Then we
grant
can
you
file a
everything. What about the subsistence allowed?
Well, at this stage, my lord,
What is it at this stage? Subsistence allowance is to be given the moment the
50%
person
is already
you
been
are
given.
putting him under suspension.
my lord, 50% is being given, my
Huh?
lord. 50%.
What is this 50%? Do you follow the FRSR?
Yes, my lord.
If it is the FRSR, if you follow, then FR says that first 3 months you have to pay 50% or then 75%.
Yes, my lord.
Then why you are not giving the 75%? Okay.
My lord.
Will issue notice, but in the meantime you follow, pay the 75%.
Yes, my lord.
Heard Miss F in touch. The learning counsel for the petitioner. Mr. Who appears for whom?
Well, I am appearing on behalf of my lord, respondent number 2 to 4, 2, 3, and 4.
Mr. Your name?
S. Das, my lord.
S.
S.
Das.
Das.
Appears on behalf of the respondent number 2, 3, and 4. And you?
Lordship respondent number 1.
Name?
N. Kalita.
The N. Kolita appears on behalf of the respondent number 1. Issue notice making it returnable on 8th of May 2023. As the respondents are duly represented, extra copies of the petition be served upon them by Wednesday, 29/3/2000. The case of the petitioner herein is that the petitioner was suspended by the order dated 30/7/2022. And have you been paid any subsistence allowance?
50%. Lord.
And the petitioner has been paid thereafter subsistence allowance at a rate of 50%. Challenging the said suspension order to be in violation to the law laid down by the Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India reported in so and so. The petitioner has prayed for reinstatement with effect from 30/10/2022. It is the further case of the petitioner that the respondent number 2, 3, and 4, respondent number 2 is governed under the FR and SR as applicable to the government of Assam. And consequently, after the initial period of 3 months, initial period of suspension of 3 months, the petitioner is entitled to the subsistence allowance at the rate of 75%. Which FR?
53, Lord.
In terms with FR 53. It is the case of the petitioner that the said that the petitioner have only been paid the subsistence allowance of 50% since the date of his suspension till date. On the other hand, Mr. Eltas, the learned counsel appearing on behalf of the respondent number 2, 3, and 4 had submitted that the departmental inquiry against the petitioner has already progressed and the petitioner had duly participated in the departmental inquiry held on
24th month of
on
March.
24/3/2023. And as such, the law laid down by the Supreme Court in the case of Ajay Kumar Chaudhary, Supra, shall not be applicable. On the other hand, the learned counsel submit that the respondent number 2 shall do the needful if the FR 53 prescribes the requirement of payment of 75% to the petitioner with effect from 30/10/2022. Taking into account the said submissions, this court is not inclined to interfere with the order of suspension at the present without permitting the petition respondents to put on record their stand. However, this court directs the respondent to pay the petitioner subsistence allowance at the rate of 75% per month with effect from 30/10/2022. The same shall be done within a period of 15 days from today.
Much obliged.
Please take order.
Item 2.
Met please, Your Lordship.
Yes,
My lord, it is regarding the apportionment of pension between
Huh?
the wives, my lord.
this is regarding
Apportionment of pension,
between.
two wives, my lord. Two wives and unmarried daughter,
Why should this court look into this?
my lord.
Why should this court look into this?
My lord, law is settled by your lordship.
Where?
That 50% it should be apportioned. Law settled by this honorable court is in this line. That pension is the property of husband and that should be distributed equally as per. law.
Oh, this one.
Yes, my lord. NS Singh,
But,
Justice NS Singh.
but, who are you?
My lord, I'm
Who-
second wife, my lord.
Second.
Yes,
Hindu.
second wife and daughter,
Second wife and daughter are Hindu. How can this be taken into account?
my lord. My lord, principle is laid down that wife is entitled with family in pension rule, my lord.
Now, can this court take judicial notice that there is a second wife
My lord.
during the lifetime of the first wife?
Yes,
Is it?
yes,
How?
that is in record, my lord.
Where? How can there be? What do you say about the Hindu Marriage Act, which categorically mentions
Yes, my lord.
that the second marriage during the lifetime of the first marriage in respect to a Hindu is void ab initio?
My lord, that aspect of the matter, I will examine, my lord.
You examine, I can't give you anything.
Notice may be
You
issued,
do
my lord.
one
Because,
thing.
my lord, Supreme
No,
Court
no,
decision
you
is
do
also
one
there.
thing, you withdraw this petition, examine, and then come.
My lord. My lord,
Without examining, where have you come?
my lord, matter may be adjourned, my lord. Because, my lord, I have examined only the High Court
You need
decision.
time till Bihu.
My lord.
You examine during Bihu
My lord, after Bihu, my lord.
at the request of the learned counsel for the petition and let the matter be listed after Bihu meeting.
I am for response number 2 only, my lord.
The it appears on behalf.
Not if I'm making to 1 and 3.
I'm not issuing notice only.
57 of supplementary leave.
Oh, this matter. You got anything?
My lord,
Yes.
on Sunday only,
Yes.
with
See,
lot of,
things move so fast. Why have you done 52?
my lord, I'm placing, my lord.
Yes.
My lord, 52 means they didn't qualify. Means, my lord, total 357 candidates appeared.
Hmm.
Out of that, my lord, only 52 could, my lord, clear. The benchmark mark was 30 for reserve category and 35 for general. They did not merit. So, my lord, once it may our, my lord, in clause 7 of the advertisement, it was, my lord, 1:4. But, my lord, they have to clear, my lord. Unless they get the minimum marks, my lord, we could not have called them.
You are general.
Generally,
You didn't even get 35%.
all of them were not expecting, but 2 or 3 expecting getting some 5 marks. Sir.
What all of them? How many petitioners are here?
6 petitioners. Sir.
Yes.
Expectation is different, but these people they didn't get through.
Lordship, but in that advertisement, there was
No mention.
there is no mention that
Understood, but don't you think the selection committee has the basis that they will have a for unreserved 35, for reserved 30?
This is minimum marks, my lord.
It is the minimum. Then,
Who has, my
then
lord?
if you couldn't get 35, how can you?
Lordship,
But for one thing, however, here, are you going to apportion this? How many posts were there?
18.
18 posts.
Only 52, my lord, the basic minimum marks only 52 have, my lord, achieved. My lord, will appreciate one thing, my lord. These people are going to tomorrow, they are going to deal with public matters, my lord. If they don't get one, my lord, minimum marks, my lord, how can government, my lord, hire them, my lord? That is also there, my lord.
No, that is okay. For them, the petitioner is okay. There's no problem. Only worry about this court is if there are 52,
52,
which means 30.
18,
Are you,
18,
are
18,
you
6.
going to apportion this to 18 posts or 13 posts?
18 posts, my lord, total. Total 18 posts.
Now, if the zone of consideration has to be 72, can you apportion it amongst 30?
My lord, that
I'm
was
not
our
on the petitioner. Petitioner's case has already been discussed. Think about it.
my lord, we while doing the advertisement, my lord, publishing the advertisement, we ever did not knew that this basic minimum marks, at least 72 out of this 357 will not get, my lord. That is why, my lord, we have a bigger umbrella so that we can have better person in the system. So, my lord, it is our ill luck that, my lord, only 52. We tried, my lord. We gave our best shot, but it is only 52 has cleared, my lord. But, my lord, the office demands, my lord, 18 people, my lord. Without that, my lord, the job has to be done, my lord. There is pressure, my lord. We have to now, since there are the only 52, my lord, we'll have to take from there only, my lord. We have given them chance, my lord. And if we go by this minus the meeting, my lord, the rejected list of the applicant in para 2, the rejected list of the applicant with reasons of rejection is to be uploaded in the, we are going to upload it, my lord, in the second para, minus the meeting, my lord. Next page. If they are aggrieved, my lord, they can challenge that thing, my lord, in the second paragraph, my lord. Then they will have to again make, my lord, this people party, my lord. If they are aggrieved that with the rejection thing, my lord. But otherwise, my lord, how can we, my lord? They did not get to the minimum marks.
So you mean to say that the petitioner, without prejudice, should withdraw the instant petition?
My lord.
And file a fresh.
File a fresh. Let him wait, my lord. This I will.
Because any order passed out here will
Yes,
affect the petitioner.
it will affect them in future court. So I will, my lord, instruct my deputy commissioner to upload this by today, so that tomorrow they can again come before this court and file a fresh writ petition. But not in this, my lord, because they did not get through, my lord. Minimum
Yes,
marks they have to
Mr.
get.
Kant.
That's it. So at this stage, if they are taking that's done, then I think I have to challenge the advertisement also. Because in the advertisement, they have not prescribed any qualifying marks. And without that being prescribed, they now cannot come out with that stand that they have to get lordship or your kind referral lordship. I have gone through this aspect of the matter, and I thought that they will take this ground only. So I have gone through certain advertisement, standard advertisement, and I have got one advertisement. I have got many, but I have got today one advertisement for your lordship and perusal. In that, they have specifically stated what type of written examination will be held and how the qualifying marks will be counted. If your lordship just go through the point number 5 of this advertisement, lordship.
No, Mr. Counsel, problem doesn't arise there. The problem is the scope of judicial review. Can this court go to the extent and say that whatever may be, this court, they have the right to appoint or right to hold an advertisement, the right to make a selection is absolutely theirs. It would only be when you are not given a fair consideration. Now, in the instant case, what they have done is they have already made their advertisement. Yes, in the advertisement, there is no parameter, however, been mentioned as to how these people will be selected.
Yes.
So the selection committee which have been appointed have taken a decision that look here, we are going to take these other methods. Now, in view of that, unless you challenge the minutes of the meeting, can this court go and say that the minutes, the selection is bad? Get the point?
No.
I don't think I should say more.
No, yes, lordship. But if there is no prescription in the advertisement, there is high much chances before the authority, recruiting authority, to go to choose, pick and choose of person of their choice, lordship. So as per this advertisement, Lordship, they should have called 72 people, irrespective of the mark they are getting in the qualifying examination. Lordship. They should have called, as per this advertisement, Lordship, they should have called 72 people.
How are they going to select?
Whoever getting 70, they will call people.
Getting
serially.
what?
Supposing one people getting 81 highest mark, next one is getting 79, next one is getting 40. Likewise, they have to call 72 people. Or if they are going to shortlist candidate as per this instruction, Lordship, then they have to incorporate that provision in the advertisement itself. Without prescribing that one, they cannot now take a stand of their choice so that they can choose and pick up people of their choice. Lordship, if your Lordship kindly peruse paragraph 5 of my advertisement which I have given, it has been clearly written how they are going to conduct a screening test. But in this and Lordship, they are going to be posted as Mandal. If Mandal are also have to get some high ranks in the competitive exam, in the written exam, then they will not have any chance to for any post, Lordship.
Oh, that can be the reason.
Lordship.
No, Mr.
No,
Counsel, no.
My lord, today they are
You
appearing to
know,
computer
Mr.
efficiency
Counsel,
test,
you
my
are
lord.
aware of the fact that how important the
Lordship.
mandals are. And how much they role they
No,
play.
Lordship, if they are getting 28 and someone they were supposed to get 32, then Lordship, they should not be deprived for 4 marks because they are not claiming some post.
My lord will appreciate the thing. This benchmark of marks, my lord. These are basic minimum marks, my lord. It's not that we have curtailed the market 50%. No, my lord. For reserve category, all categories, it is 30%. And for general, my lord, it's 35. That's it.
And moreover, Lordship, if they are not getting 72 people at this stage, they should have gone for press recruitment. They cannot now accommodate people from the select list that has been prepared for the 52 people, Lordship.
What do you want to do? Withdraw or should I dictate?
Lordship,
I give you an option.
if your Lordship going to dismiss,
Oh, definitely. I think, Mr. Counsel, the best option is you withdraw. With liberty to file, challenge the selection minutes. No, it's not a minute. It is done by the
Second page is minus.
selection committee's minutes. Without challenging this, would it be possible? This
Yes,
court
sir.
doesn't see any unfairness because this was done on 15/3/2023. And your select test was held on 23/2023. Is it or not?
yes, sir.
So therefore, this was done prior to that. So under such circumstances, what you are submitting, you want to challenge it, you challenge it. But otherwise, if you want to, otherwise, without challenging this court doesn't find any infirmity. And if the court has to dismiss it, then this court have to give the reasons that they couldn't find anything, and as such, it has been rightly done without a challenge to these minutes.
Lordship, I have
Because you see, the scope of judicial review you have is not unlimited. We can't enter into their fold. They have the right to select whoever it is. They will only, we are to only see as to whether it meets the reasonableness, reasonableness out there, as to whether it is reasonable to them, their actions. They have taken up a decision on 15/3/2023 that we have received 357 candidates. And out of these 357 candidates has to be done by something. So what we do, we have a cutoff mark of 35 for unreserved and for reserved 30. Whoever gets through, it's good and fine. We'll give it to them.
Lordship,
But tell me one thing. have you invited these people? Now, just for example, you don't have any limitation on reserve and unreserved applying. Do you have a limitation? No. So there might be a case where there are 50% or 60 among the people who are applying, there might be 50 or 60% of them who belong to the reserve category,
My lord,
and 40% belong to the unreserved.
my lord. My lord. I understand.
Are you not having a different yardstick for bringing the yard? Because if they get 30,
My lord.
which constitutes 60%, and you have the mark, you have as per your advertisement,
My lord, if
as per your
for
advertisement,
unreserved, my lord, there are 7 seats.
Hmm?
My lord, in
Ah.
our,
you see what you have done. You have the post which is there
yes,
is unreserved is 10,
10, 7 plus 3. For 7 for male and
whatever
my
maybe
lord,
10.
OBC 4,
OBC is 6.
6.
The total is 6, of
6.
which RFW is 2.
My lord.
Okay. Now, if it is 6 OBC, that means any other, just for example, out of 357 candidates,
My lord.
if there are 60% who belong to the OBC
My lord.
and get 30 marks,
My lord.
you will be entering them within the fold of the general category also, if this is to be adopted.
My lord, we have done, for my understanding, my lord, these are in roster points, my lord. This has been calculated, my lord. Maybe as of today, my lord, these are vacant posts. We have to fill up, my lord. So, my lord, so accordingly, my lord, out of 52, my lord, I don't have the entire chart with me, my lord. Who are the people? So, my lord, they will be accordingly who gets from, my lord.
No. What I am saying is, you are having a benchmark of 35 and 30, unreserved 35, reserved 30.
My lord.
So if the 357 candidates constitute of 60% of unreserved or 70% of unreserved, and they get 50%, 30%,
My lord.
they make inroads into the category of general.
No, my lord. Posts are reserved, my lord. Because
Understood. But,
we can.
but if you see this particular clause 6, it says,
My lord.
it is decided that the minimum cutoff marks to be shortlisted for appearing
My lord.
in the practical test shall be 35 of the total marks for open category candidates,
My lord.
and 30% for reserved category candidates.
My lord. However, candidates shall be shortlisted purely in the order of merit
based on the total marks obtained in the written test.
written exam.
So, a person who gets 30 in the reserve category would be taken into consideration if you are having the minimum for reserve as 30.
No, my lord, they will not cut into the thing of, because it is reserved. No, for 10 we have kept for unreserved categories. They will not cut, my lord.
Let us have the marks of those people. You are only 52. Get it on Wednesday?
I can get the list.
Because then we find out that these people out there and what did the petitioners get.
My
Easier.
My that I can.
You give him a copy of this minutes. Have you given him? I'll record it in the order.
Yes.
Heard Mr. A.D. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. N. Dhar appears, appears on behalf of the respondent number 2 and 3. And Mr. S. Dutta appears for the respondent number 1. Pursuant to the order dated 24/3/2023, the Learned Council appearing on behalf of the Deputy Commissioner Nalbari have apprised this court that prior to the pursuant to the selection advertisement dated 1/3/2023, the selection committee in its minutes dated 15th of March 2023, after taking into account that there were 357 candidates who had applied to the post of lot mandal, had envisaged had set out the manner in which the selection is to be carried out. The resolutions were taken in the minutes of the meeting dated 15/3/2023 are as hereinunder. Eh, no, but 10, 11 like a DD. From the perusal of the said resolutions public decisions so taken in the minutes of the meeting dated 15th of March 2023, it transpires that the selection committee had decided that the minimum cut-off marks to be shortlisted for appearing in the practical test shall be 35 marks, 35% of the total marks for open category candidate, and 30% of the total marks for reserved category candidates. It was further observed that the candidates shall be shortlisted purely in order of merit, based on the total marks obtained in the written examination. In terms with the said decision, after the practical test was held on 23/2023.
The 19th.
It was found that only 52 candidates out of 357 on 23/2023, when the practical test was held, Mr. Counsel, you see, as per the minute, practical test was to be held on 23/2023.
Based on the result on shortlisted in the ratio of practical test to be held on. That is what we are doing it today, my lord.
23/2023.
Yes.
We are at 27.
Yes, my lord. That was decided on, my lord. 15.
When did you hold the written test?
19th.
Here the answer is at paragraph number 2 of your instruction. However, it appears that in written test held on 19th of March 2023, only 134 candidates appeared as per the state advertised. As per the further instructions so provided by the Deputy Commissioner Nalbari, it transpired that though the selection committee was supposed to shortlist 72 candidates, but considering reservation of candidates as above and the merit in order of marks, only 52 candidates have been found eligible to be shortlisted for the computer proficiency test practical to be held on 27/3/2023. It is under such circumstances, only 52 candidates The roll numbers of only 52 candidates have been mentioned in the order dated 22/3/2023. Let the matter be again listed on 31st on 31st of March 2023. On which date the learned counsel appearing on behalf of the Deputy Commissioner Nalbari shall produce before this court the result sheet of the 134 candidates who appeared in the written test held on 19/3/2023. And the marks obtained by them.
My lord, means all the candidates.
Only 134. Only 134 appeared. There cannot be more than that. Isn't it? As per paragraph 2, I hope you stick to your instructions.
My lord, there were 357.
Mr. Dhar,
My lord,
kindly
my lord.
see paragraph 2.
Okay.
So I can't ask for
My lord, my lord, my
357.
lord, my lord.
The instructions were placed by Mr. Ardhar is kept on record and marked with the letter X.
Copy of the minutes to be given.
Huh?
Copy of the minutes to be given that we report.
The interim order passed earlier on 24/3/2023 is extended till the next day.
Lordship, also not to declare the result of the computer test. Lordship. Till then.
That is what, my lord,
Mr. Counsel, don't ask for more than that.
that is what, my lord, we are going to conduct the exam, only will not declare the result. That is what, that was the direction.
Then how can you be?
Lordship, till 31st, not to declare the result, Lordship,
Why?
because
You want the results?
I just Lordship 31st only they are going to produce the mark sheet, Lordship. If I don't have case, then they will publish, Lordship. But till then, Lordship.
So publish. You challenge it thereafter. I have given you, given him there's an interim order that they can go ahead with the selection, only not to publish the results. That's it.
Oblige, Lordship.
For admission item 3, part heart.
Lordship,
Hmm.
Lordship, I have taken the steps, but since it has the additional affidavit has not reached the reports yet. Lordship, may I pray for a
Why
short?
it has been 8? Yes.
Lordship, may I pray for some time so that the affidavit may come place in the record and then
Okay, we'll have it some other day. This has been wrongly shown as part of.
no, it was a part that
Otherwise, my lord, the ROP 2017 has now been amended.
Oh.
And that amendment portion has not been put to challenge.
Oh.
And it is pending before the division bench.
Lordship, we have filed one additional affidavit, Lordship, but it has not
That
yet
will
reached
not
the
help much.
maybe given a date, your Lordship.
Hopefully.
So I gave you a liberty to file an affidavit, bringing on record as
Yes,
to
yes,
whether
your
you are a trained graduate teacher or untrained graduate.
Yes, your lordship.
And you are
I'm graduate.
graduate is
teacher,
okay.
lordship.
The
No,
main
we
problem is not the graduate. The main problem is the trained or
Lordship, we
untrained.
will not detailed for the training. Even though we want to, we will not detail. Because sir,
What is a trained graduate teacher?
Lordship, they had
Ah, Mr.
given a
Vivek,
program.
what is a trained graduate teacher? A person who undergoes a training.
Yes, your lord.
You have underwent training.
Lordship, as per the program, it has been stated that the people who, the teachers who had joined or appointed before 2001, they will be considered as trained. So they need not to go into the training. And it is, I have annexed it in the main petition, your
In
lord.
your additional affidavit.
No, in the main petition, your lordship. In annex number.
Anyways, we'll
120.
require the additional affidavit.
Yes.
That is what you are saying.
Yes, your lordship.
Chalo, let the matter be listed. When? After 2 weeks?
Maybe listed by a date, your lordship. Maybe fixed by a date.
Okay, we'll have it a date. Let us have it on 11th of April.
That will do, your lord.
Let the matter be listed on 11th of April.
It will
So in the meantime, the additional affidavit so filed be brought on record. It, however, surprises this court. It is relevant to take note of that this court, by the order dated 23/2/2023, have categorically observed that the matter was released from Parthad. However, it surprised the court as to why the registry has again listed the matter as a Parthad. The registry has shown the matter as Parthad. The registry shall do the need.
Item 5.
Take your lordship.
Yes.
Lordship, my senior.
Oh, that matter.
Yes, lordship.
Yes, Mr. Samoa.
Lord, so far as their case is concerned, I see the case briefless. Actually, the person, the petitioner, she got the regularization. He was initially appointed as a against a non-sanctioned post.
Yes, tell me.
She initially was appointed in a non-sanctioned post, my lord. Then her post was regularized in the year 2014. She did not have the requisite qualification of UGC norms. But when she was regularized, there is a condition given to the regulation order that within 2 years from that particular date in 2014, she has to acquire the qualification. Now it is not known to us, so far as the petition is concerned, whether she has got the qualification or not. And if she has not got the qualification, then her service will be discontinued.
Where is that?
That is in that is the page 28 and Annex 10. Point number 3.
Okay. Now, you are?
I am for the University Grants College.
I'm hired.
What is your instruct?
Same, my lord, same argument, my lord, that at the time of regularization, my lord.
That I have got it. I also understood that. I'm only asking you. There's a requirement of the college informing you as to whether within 2 years they have got it or not. Has the college informed you?
My lord, regarding that, I have no inspector. My lord.
Why? This is a matter of 2016.
This matter is
They have
this
not
matter
stated in the petition.
Huh?
they have not stated anything regarding.
No, forget about what the petitioner states.
Moreover, my lord,
But the court cannot dismiss the petitioner's case just on the basis of that. So you have to come up with instructions. Because this matter is pending from 2016.
2016, my lord.
Only thing is you had to know, because you see, kindly see annexure 10, page 28. I hope you have the brief.
Yes, yes.
And the college authority have to inform the director of higher education forthwith. You get the line?
That is in bold capital letter.
Now, what about number 4? What is this letter of higher education dated 30/10/2010? Yes,
My lord, kindly give us some time, my lord. I will bring updated status, my lord, regarding whether the petitioner has.
how many affidavits you have filed?
I filed one affidavit.
Oh. Who is the respondent number 3?
Director, my lord.
One affidavit.
Yes, my lord.
But the record shows there are 2 affidavits. One is filed in 2019 and one is filed in 2021. Now the council, would you, as a council of the Director of Higher Education, are you going to withdraw a affidavit? Or are you not aware of what is the matter about? Or you didn't get the time to look into the brief? Or you thought that the looking into the brief is not essential? Which one of it is correct?
My lord,
Yes, madam, where is your senior?
My senior is out of.
No, out of station wouldn't work. Tell me only one thing. Have you got your PhD?
Or next.
Net or SLET? You got it? We'll take it up at 2. Not 2, 12:15. Get your instructions. I'll dispose of, otherwise I'll dismiss this. And Mr. Council,
yes, my lord.
kindly get your records properly.
Yes, my lord.
This is not how the government council should act. Don't know how many affidavits you have.
6. My lord, 6 may be time being, my lord. Mr.
Why?
K. Gogoi
You
will
have
argue-
not prepared that also.
No, my lord, Mr. K. Gogoi will argue, my lord.
Not concerned. Let's see. If nobody appears, we'll take it up. Yes, what is your case?
Always need some time for instruction, madam. For instruction, madam. We have been trying to contact the
Who?
petitioner, madam.
What is your case?
But the cases regarding the discontinuation of the annual increment, your
Huh?
Challenge is made with the
What have
discontinuation
you
of the
asked
annual
for?
increment, madam, at page 26.
Setting aside the communication of 11/8/2011 issued by the principal Iman, whereby the annual increments
Yes.
of the petitioner have been stopped with effect from Iman purportedly in terms with the verbal communication of the higher education.
And we have to receive, because the affidavit has been received, madam. Let us say that we have to be subject to the condition of clearing the net and slate, madam. Content condition of.
UGC,
Madam, yes, madam.
here also same thing.
Madam, we have to receive instruction, whether he has, as per my knowledge, but he has cleared, madam. We have to receive that instruction, madam. We have been trying to communicate, but.
Let us see that the communication which you are challenging.
On the page 26.
Page?
On the date 11 August 2011.
Page?
Page 26 of my petition.
26.
Madam.
What is the letter? Until the validity of which letter?
My lord, the letter 2003, my lord, page 23, my lord. Like hereby, madam, we have been exempted also, we've been regularized. Okay. Page 23.
Have you completed the net SLET PhD?
We have been trying to receive the instruction, my lord.
No. What is this instruction of
Madam,
2016 matter?
My lord, from since yesterday, we've been trying to coordinate.
So you don't know.
Lordship may give us 1 week time.
No, no,
we see
they-
the instruction on the next date we'll apply.
Mr. Counsel, you have been regularized. When?
But as per the order 2003, my lord. I've been
Let us see the order.
At page 23, my lord.
Page
23, my lord.
Resolution A of the governing body regulating the service of the land in English by convention released to the approved with effect of one second.
After this, my lord,
So you have been brought on service since 2001.
2001, my lord, earlier with the condition that subject to the clearing of the net step, my lord. Then in the year 2003, that orders have been kept in abeyance, my lord. They have also been given money revised using. I've also been given, my lord, incremental benefit of salary after that, my lord, after the 2003. But
Page
not-
24.
But page 26, my lord. At page 24, yes, my lord.
Yes, but that has been therefore put,
Put on, my
the
lord, vote.
director of higher education have asked the principal, are you going to pay it from your own pocket or it has to be done in terms with that?
My lord.
Then,
My lord, that, my lord, it has been challenged.
and
my
if
lord.
you have not, then you have to return back the money. Have you retired?
No, man.
Then,
Sometime maybe granted, my lord, next week,
no,
my lord,
no,
we'll apply
no
6 more, my
business of timing of 2006 matters,
lord. My
sorry.
lord, tomorrow, my lord.
No, no, well, I can give you till 12:15, that's all.
My lord, no, we've been trying since yesterday, my lord.
Sorry, I can't help you.
My lord, tomorrow, my lord, this is last chance. We have to receive.
Sorry, no tomorrow business. Let us see the affidavit of the respondent number 3. Now, higher education, that's provincialization rule. Education. Yes. Council for the higher education, do you have the education manual? They are regularized under what provision?
Yeah, my lord,
No idea. Interestingly, I also don't have the book. Okay, we'll take it up at 12:15. Get your instruction. What this court will pass that if you are otherwise, if you have cleared the net, SLET or the PhD, then you will be entitled. Otherwise, no, matter ends. Because the UGC guidelines of 2000 categorically mandates that those persons who have been appointed after 24/12/1998 has to have this. Well, Question of interference with this order doesn't arise. You are to have this. Have it. Do you have it or not? That is another question. Get hold of those.
Item 8.
12:15.
Wait, Your Lordship.
Yes.
In this matter, my lord, the petitioner was appointed in the year 1999, my lord. My lord, after that, my lord, although he was appointed against regular scale of pay, but
For payment of area salary along with other admissible under the law, admissible position till date since you are asking for area salary
yes, Your Lordship.
till date since 23/11/2010. Yes, what is your instruction? No instruction.
My lord.
Why? A matter of 2007, you have no instructions. Now tell me, the cost has to be imposed upon whom?
Lordship,
Upon you?
taken up at 2, my lord, in the meantime, my lord.
That is a battle. It's your instruction of
My lord.
I impose cost. But this is not a matter of 2017, a person having not got the, what you call the area salary from 2010. You are appointed properly.
My lord,
99,
no,
my
actually,
lord. 99.
I was appointed against the OBB post, my lord.
Oh, yes, then
Later, my lord, I have approached this honorable court and whereby honorable court directed the authority to release salary. But in the meantime, I have approached this court again for regular election in a wrong assumption, my lord, because I was appointed against regular scale of.
following Nirmali Bora. You come within the 7066,
No, no, no,
4040.
no.
Then there are two only OBB. There is no other OBB. If you come under another OBB, there is no OBB. The government of Assam had taken two OBB. One is 4040 and other is 7066. In which category you come?
My lord,
You have your appointment letter?
yes, your lord.
Show me. I'll do the. Oh, interesting.
At page 16, my lord.
Where is your appointment letter?
At page 16, Annexure C.
So you were initially appointed on 24/4/1998. So you come under the 4040.
Yes, your lord.
Annexure A, page 14, my lord.
8.
Page 14, certificate issued by.
What is this?
Headmaster.
Certificate issued by headmaster, my lord, is appointed under OBB scheme as assistant.
Oh, who is the headmaster to say? Subject to discharge without notice and without any assigning any man is hereby temporarily as assistant teacher in the scale of so plus mark. This was given in 99. So that means he was brought within the Iman. So you come under this 2734. Prayer for doing the needful. Then you file a writ petition.
Yes, your lord.
Respondent shall within a period of 2 months from today make payment of the unpaid dues of the year with effect from a month. This order was passed in 2003. Shall furnish to the respondent certified copy of this order. Then
Again, I have approached the by filing an writ petition.
The appointment of the made against the vacancy for the transfer of without it then
My lord, in that
this order in 2008 is disastrous for you. Then 2010,
on that basis,
you are
contempt was
filing a
dismissed.
contempt.
Yes, Your Lord.
If it is thought that they was legally appointed, they have due to deficiency of vacancy.
My lord, I was once suspended also, my lord, for not attending in the school.
Mr. Counsel, what do you say about this 2008 order?
Yes, my lord, in this regard, I have.
That is a very dangerous order for you.
Yes.
What right do you have?
And my lord, page 33, same order, my lord.
Huh?
Another repetition file, my lord. Page 33 order, my lord, kindly.
You said that the petitioner has been filing repetition after another, but this order is dangerous. 19/9/2008.
Yes, Your Lord.
Then what right do you have
My
to
lord,
get salary?
My lord, I am claiming salary only because, my lord, during that period, during penalty of writ petition, the authority has compelling me to attend in the school, my lord. In this regard, I have annexed.
No, understood, but
suspension
you
order,
were
my lord.
not appointed properly.
Yes,
It is in view of the order of 19/9/2008.
Yes, my lord.
It is a pure and simple case where your appointment is illegal.
Yes, considered by the.
So if it
Honorable
is
Court in
illegal,
this
then
regard,
where is
my
the
lord.
question of you getting any salary?
My lord, the state has expecting my services continue till today, my lord.
So you shouldn't have given the services.
If the authority dismiss my service on that basis, then I am not here.
And why did you withdraw the earlier petition
My lord,
by Justice Monojit Bhuiya?
yes, my lord.
The same was the claim from 2099 till date,
Yes.
till 2015.
In this
And
regard,
then
my
the
lord,
submission made is taken on board in view of the above and on the prayer of Mr. Ujit to withdraw the matter as well as the liberty to approach the court if the advice is granted. And as such, you have filed it.
Yes.
After another 6 years.
my lord, in this regard, kindly have a look at page 33, my lord. Here, Honorable Court held that the petitioner had filed a present writ petition again seeking a direction of this court to the state respondent for payment of his arrear salary with effect from 5/4/99 as well as his current salary. Having regard to the order passed in the contempt application, perhaps it would not be open for a petitioner to claim arrear salary for the period from 5/4/99 till that, when the contempt application was disposed of by this court. Because of that, when the contempt petition was dismissed. Thereafter, I am claiming, my lord, since 2010, my lord.
So, because of the contempt order,
Yes, your lord.
then how do you get it? You knew it then also. Then also, why are you continuing?
My lord, the authority has not any action has been taken against me, my lord, for dismissing or removing my service, my lord.
How do you dismiss somebody if you have not appointed?
My lord, in this regard, I like to draw attention of your
Of the suspension order?
Yes, your lord.
Yes. They
Company,
keep
my
on
lord.
doing many things.
And even after that, my lord,
The element, you are elementary or secondary?
Elementary.
They are the greatest. They
and
will do
again,
many things. The elementary education department and the secondary education department may go to any extent to legalize for the purpose of doing this. How to do it? But the question is, how do you take care of the judgment of Justice Gogoi? How do you take care of the judgment of B.K. Sharma? Where it has been categorically mentioned, you see, in the order in question, direction was given to pay the salary only if found that the petitioner was legally appointed.
yes, your lord.
That being the categorical finding that the petitioner was not legally appointed, there is no question of payment of area salary. Now, with this order being there, without this being set aside, how can this court give you anything? Tell me. I can't help you.
My lord, your lordship is correct in this point, my lord.
Huh?
Your lordship is correct, my lord. But thing is that I think as per Article
Understood,
23, my lord.
but Mr. Counsel, you have to understand. Is any order or what you are asking for, if this court passes, na, this will open another Pandora's box. You can't do that. I can't help you with anything with these observations being. Okay, heard, Mr.
I'm sorry, my lord.
And so the learned counsel appearing on behalf of the petitioner and Mr. B. Taluka appearing on behalf of the elementary education department. The case of the petitioner herein is that the petitioner have not received his area salaries. Till the date of filing of the writ petition since 23/10/2010. It is interesting to take note of that this is not the first round of litigation by which the petitioner has been claiming the area salary. The petitioner initially filed a writ petition in 2003, being WPC number 728/2003, whereby this court, by an order dated 31/1/2003, disposed of the said writ petition with a direction for payment of the area salary to the petitioner, provided he have been legally appointed. However, the respondents did not pay the the area salary as well as the salary to the petitioner, for which the petitioner had filed a contempt proceedings, being contempt con case C 255/2004. During the pendency of the said contempt proceedings, the petitioner filed another writ petition on no, I do not. Contempt case Pursuant thereto, the petitioner filed another writ petition before this court, which was registered and numbered as WPC number 7481/2003. This court, by an order dated 19/9/2008, the said writ petition was filed for the purpose of regularization of the claiming regularization of the services of the petitioner. However, the said writ petition was dismissed by an order dated 19/9/2008, which is extracted here in below, page 21. It further appears that the petitioner thereafter filed an application initiating contempt for non-compliance to the order dated 31/3/2003. The said case 255/2004 was, however, dismissed holding inter alia that the petitioner was not legally appointed, and as such, there is no question of payment of area salary to the petitioner in terms with the order dated 31/1/2003 passed in WPC number 728/2003. The said orders dated 22/11/2020 is extracted here in below, page 22 and 23. Thereupon, the petitioner filed another writ petition, that is WPG number 4676/2011, claiming area salary with effect from 5/4/1999 till the date of filing of the writ petition. The said writ petition was, however, withdrawn with liberty to refile. Thereupon, the present writ petition has been filed. The orders passed dated 19/9/2008 as well as 22/11/2010 as extracted herein above makes it clear that the petitioner's appointment was not legal. The appointment of the petitioner was illegal. Considering the above, this court is of the this court is constrained to observe that the petitioner is not entitled to any salary as claimed in the instant writ petition on the ground of being illegally appointed, on the ground of the appointment of the petitioner being illegal. Consequently, the petition stands dismissed.
তোমাকে ডিসকাস করবো বলেছে
May I be
Yes.
Let's see, this case now last more than 6 years, no response from the respondent side, my lord. In fact, it is a covered case, my lord. It's covered by the judgment dated 8/8/16 passed by the Honorable Justice we are taking aid over FS code, my lord. I have annexed and on 29/11/17, respondent side issued before the court that he will take instruction whether it is covered or not. In between, my lord, they have not preferred any appeal review, my lord, for those judgment, my lord. So at
Which is the
finality, my
case?
lord,
What is your case,
my
Mr.?
lord, my case is, my lord, we are initially appointed as STEM teacher, my lord,
Hmm.
in 1988, 1999, my lord. We completed the junior basic training
1998, 99.
1998, 99.
Okay, then.
99. Then after 8 years, my lord, we are categorized as access teachers. My lord.
Oh, then.
Then, my lord, after 11 years, my lord, categorized as a supernumerary teachers. So, my lord, fully covered by the judgment passed by this, that is in page 71, lordship, and they haven't challenged that judgment, my lord. No, not prefer any appeal or review, my lord. So attain finality, and it is a settled law, my lord. Doctrine of finality has to be applied in strict legal sense, my lord. Otherwise, it will be cast in the
Doctrine of?
administration. It attained finality, my lord. Last 6-7 years, my lord. No review, no appeal, my lord. That judgment.
Which one?
That is, my lord, page 70.
Page 85?
Yes, page 71, my lord. Reviewing para is page 80, my lord. Page 71, my lord.
Yeah.
And relevant portion is, my lord. Page 70 is, yes. Page 78, my lord, paragraph 14, my lord. And lordship, basing upon the judgment, another 2 judgment passed, my lord. Maybe more, my lord. Another 2 judgment passed.
পোৱা নাই নহয় 2টা বজাত লগ নহ'লে কৰিব পাৰোঁ
Yes, Mr. Talukdar.
My lord, in this matter, lordship taken up at two or next
Why?
or another, because my lord, maybe they are adjusted or accommodated, my lord, Sipsagar, my lord, illegal and irregular teacher, my lord. So maybe they are at the,
In 2020.
my lord. My lord.
In 2020, do you have, there was a move of accommodation being made.
My lord, screening committee, my lord, 3 list, my lord. So I have to take instruction in this matter, whether they are.
Screening committee report is faulty and defaulty.
Hmm?
Screening committee report is, my lord, faulty, my lord. We are not.
No, Mr. Counsel, that is not the question. The question is, there are certain actions which have been taken
Good.
in respect to those excess teachers, not excess teachers, some irregular or illegal appointments which were there were regularized, subject to waiving of their claims of area salary.
We are when the gov created supernumerary creation of government itself, right? It cannot be a irregular illegal. Gov created supernumerary.
You were?
Gov created supernumerary post. They admitted me.
Government created.
Government created
Supernumerary.
supernumerary post. As for supernumerary post, my FSQ is very much clear. That is the judgment passed by this. Your lordship is already produced, my lord. And subsequently, this judgment, my lord, another 2 judgments, maybe more, my lord. First, my lord. The relief sought for and the cause of action, same, my lord. The similar case, my lord. Ditto, my lord. So, for that, my lord, on they I took time and all that is on 29/11/17 instruction, whether it is covered or not, my lord. They were fine, my lord, it is not covered. If it is covered, they admit it is not covered. They will revert it, my lord. So, my lord, since it is attained finality, my lord, no appeal, no review, plus 6-7 years, my lord.
At 2, my lord, I will apply the allow the board.
What is your present status?
My lord, still continuing, my lord. Without salary, my lord. Last, I think, is it 12. Form 2012, my lord. They have the further instruction we need, my lord. Keep, my lord. So, for my knowledge, until 2012.
Today, there is no finance.
My lord, I have to take instruction whether presently they are getting out of my lord.
D. Gugoi is on legs in code number 10.
Who?
D. Gugoi, lord. He's on legs in code number 10.
Yeah, I have to take instruction. I am not sure whether still they are getting on of that. I am not submit anything without my knowledge. So, from my knowledge, 2012, my lord, it was stopped, my lord. Then, so for salary part, my lord, I have to take instruction.
Heard Mr. M.U. Ahmed, the learned counsel for the petitioner. The P. Talukdar appears on behalf of the elementary. Is it elementary?
Elementary.
Elementary education department. The learned counsel for the petitioner submit that the case of the petitioner is squarely covered by the judgments passed by coordinate benches in the case of Horen Borgohain and 21 others versus the state of Assam. Dated 8/8/2016 in WPC number 3045/2012. comma, semicolon, Nilim Buragohai and 23 others versus the state of Assam and 4 others in WPC number 1449/2014, dated 10/2/2017, as well as in the case of Prasanto Gogoi and 17 others versus state of Assam in WPC number 2712/2017 by judgment dated 19/5/2017. It is the case of the petitioners as submitted by the Learned Council that the said judgments so passed by the coordinate benches have already attained finality, and at present all coordinate benches are also following the law, the following the said judgments in identical situations. On the other hand, Mr. B. Talukdar, the learned the Learned Council, appearing on behalf of the Elementary Education Department, has submitted that he has to take instructions in the matter as to whether the petitioner recent decision of the government in the year 2020. The Learned Council for the petitioner also submits that he has no instruction as regards the present state of affairs, taking into account that the petition was filed in the year 2017. Right? Accordingly, let the matter be listed on 10th of April 2023, on which day both the Learned Council for the petitioner as well as Mr. B. Talukdar, the Learned Council, appearing on behalf of the Elementary Education Department, shall take the necessary instructions in the matter. The registry shall show the name of Mr. B. Talukdar as the Learned Council, appearing on behalf of the Elementary Education Department in the courts. Mr. Talukdar, I don't want later on, no instruction.
Time being item 5.
Yes. Mr. Gogoi, it's a very sorry state of affairs of the Director of Higher Education. That the Council for the Director of Higher Education doesn't know how many affidavits have been filed by the Director of Higher Education.
Lordships, here Lordship, 2 affidavit was filed, Lordship.
I know that. But why does the Council appearing on behalf of the Higher Education doesn't know that?
That part I'm apologize.
Yes, tell me.
Your Lordship, as per government letter dated 4th of September 2019, there's an exemption of the condition of NET, SLT, MPhil, and PhD to a section of college teachers appointment for 24/12/1998, Your Lordship. And our petitioner is appointed on 16/10/97. So it is not mandatory for the petitioner to obtain NET, SLT as per the government notification.
But what do you say about the regularization? We have accepted the regularization order of 2014.
That is as per the government UGC norm 2004, Your Lordship.
Understood. If you have accepted this, wherein it mandates that you are required to have a NET, SLET, or PhD, how do you take care of that within a period of 2 years? And are you still working?
Yes, Your Lordship. Yeah.
Yes.
Lordship, they are still working, but Lordship, they have not fulfilled the conditional appointment criteria, Lordship, till today, Lordship. Although there is a conditions that if they will fail to, Lordship, to fulfill the criteria, they will be, Lordship, released from the job, lordship, that part was not done by the authority. But they have to acquire the net and slate qualification. The conditional appointment, lordship, they are appointed under the 17/7/2004 OM, lordship. Already my lords have dealt with this matter, lordship, in Robin Summers case, lordship, has detailed order passed, lordship.
Huh?
In Robin Summers case, lordship has detailed order passed regarding that particular OM, lordship.
Which one?
Robin Summers case, lordship, they are basically seeking the seniority from the date of initial appointment. That part was lordship has already dealt with. They also appointed under the 17/7/2004 OM, lord. Originally, they are in a non-existence post, lordship. Petitioner also in non-existence post, lord.
Oh, this matter.
Lordship. My lord's observation is also there, lordship, regarding their our part for regulation by violating the constitutional bench judgment of the Honorable Apex Court, lord.
Which one? The petitioners were appointed again non-sanctioned posts.
Non-existent,
Their
non-sanctioned posts.
appointments
Here
were
also,
illegal.
lordship.
However, taking into consideration the various policies were working for 5 to 14 years. A decision was taken by the government of Assam pursuant to the order passed by this court by the office memorandum dated 17/7/2004 to regularize the services of various colleges appointed to non-sanctioned by adjusting against sanctioned posts of different departments of the same college, or future vacancy or sanctioned posts of different. Further to that, the government has also created petitional personal posts to accommodate such. Understood that this court is of the opinion that the ratio laid down by the Supreme Court is actually applies to the fact that they shall be entitled to seniority only from the date of their order of regularization and not from the date of the initial inspection. Therefore, does not find any merit in the fact that the observation against now, if you see one thing, Mr. Gogoi, kindly come out here to the clause number 4, page 28 of his writ petition.
The page 28, lordship.
Clause number 3 states that the incumbent working under the non-sanctioned post and who is adjusted against vacant sanctioned post will be required to qualify net, SLET or PhD within 2 years from the date of formal approval of the appointment. Failing which so and so has to be discontinued as per the government OM dated 17/7/2004.
Lordship.
Now this 17/7/2004 is where?
Lordship.
Where is the 17/7?
17/7/2004 OM is lordship has discussed lordship's judgment also, lord. In this judgment, lordship. Here, lordship, OM is not annexed here, but lordship, in our affidavit, lordship, we have stated it. Lordship has detailed discussion is there
Perusal
regarding
of the office memorandum letter to show that the government of Assam did not create any additional post, but in return to clause 4 prescribe the manner in which the college teachers appointed to non-sanctioned posts could be adjusted against the post of other departments of the same college or future vacancies of posts of student.
my lord judgment, paragraph 3. Page 4 of the Lordship judgment, the when the relevant portion is quoted.
What was the UGC regulation at that point of time?
UGC's regulation 1998 is there, Lordship, at the relevant point of time, Lordship.
24/12/1990.
98, Lordship.
It was net slat and
Net slate is
PAP.
mandatory, Lordship. Even Lordship from 1978, Lordship. Net slate is mandatory by the notification issued by the Lordship Ministry of Human Resource Development Department, Lordship. And we have followed it, Lordship. Regarding
But what do you say about Justice Bhuiya's judgment, which have been enclosed to the petition?
Lordships, in this case, that will be not, because it's a conditional appointment of the petitioner's Lordship.
You see
This
that
is in respect of rounding of marks, Lordship.
no.
Around 52.585, Lordship. It is a rounding of marks, Lordship.
No, kindly see here,
Lordship.
page 26.
Lordship.
The petitioner there was a date of advertisement of 88, interview GB resolution.
Lordship.
88, date of appointment 88, date of joining 88.
Lordship.
Next step obtained MPhil.
Lordship.
Percentage of marks in master degree
Lordship,
so remarks no UGC norm.
Lordship.
From the above, it is clear that the petitioner's selection and appointment were prior to 15/12/1988. However, in the final list dated, even the petitioner is excluded as is evident for the
Lordship, regarding percentage of marks at that point of time, it was a rounding up by the UGC, Lordship, 52.5 marks. So that case is there, Lordship.
Yes, let us read the paragraph 15.
Lordship.
That the requirement is that the appointment should be made against non-sanctioned posts by following the due procedure and having the UGC norm required. In the opinion of this court, the term UGC norm required would mean the UGC norm prevalent as on the date of selection and appointment. In the case of the petitioner, as noticed, he was appointed on IMAT and joined on IMAT. At that time, the UGC norm was 52.5% of the minimum marks in the master degree. The petitioner had 52.62.
Here,
in his
Lordship,
master
the
degree.
issue is that, Lordship, he is not the 55% of marks, Lordship. The Honorable Court observation is that at the relevant point of the minimum percentage mark is 52.5, Lordship. So here the percentage of marks, Lordship.
We can assume that the higher norm of having minimum 55 in the area would not be applicable to the who were appointed on or before. And they would be entitled to relaxation to one similar benefit if it extended to- But it does not, because at that point of time, as I could see from your affidavit, on 24/12/1998, he was the UGC norm was net slat and or PhD.
Net slate or PhD or 55% of marks along with net slate, Lordship.
Is it so? Where is it?
Lordship, as per 1998 UGC regulation.
No, you have stated out here.
Lordship.
In your additional affidavit,
Paragraph 7, Lordship.
yeah,
Paragraph 7, Lordship, we have stated, Lordship.
of which affidavit?
Affidavit, Lordship, second affidavit, 18 to 2020, Lordship, affidavit. File on
No,
18.
no, that is, we have two affidavits. One is
Lordship.
of 23/2019.
Lordship, the affidavit which was filed on 2020, Lordship.
There is no affidavit of 2020. We have an affidavit of 2021. Are you referring to the first matter, this one?
Lordship, Anju Sharma.
Yes, Anju Sharma.
Anju Sharma.
We have two affidavits. One was filed on 28th of March 2019.
Lordship.
The other is on 7th of January 2021.
That affidavit, Lordship.
Okay.
That
It is under your signature.
Lordship.
Yes, where we went the terms and conditions. Wait, somewhere. Yeah, para 7.
Lordship, Lordship.
There is no 52% mentioned.
Here, Lordship, issue is not 52%. Here, issue is Lordship, he has not acquired the Lordship, issue is
Net slate.
net and slate. Lordship. Net and slate. Lordship. Net and slate is a mandatory. Regarding that, Lordship, may in the Annexer 10, page 28, Lordship may kindly peruse where in the
Yeah, that I have seen it.
in the 4 also, Lordship, we have said that Lordship basic pay of the UGC was 8,000 at the relevant point of time, Lordship.
Hmm.
Now it was enhanced, Lordship, and now petitioner is getting the enhanced basic pay, Lord.
Hmm.
And this issue was also decided by another case in the coordinate bench, Lordship. Regarding they also prefer the repetition for exemption of the net slate period and for Lordship getting the UGC scale of pay. Honorable Court said that we cannot interfere it because by following the principles of law laid down by Honorable Apex Court in MP Palanaswamy's case, Lordship, there are conditional appointment clause. Honorable Court did not interfere it. Honorable Court extend the time for 2 years to 5 years, Lordship, for completion of net and slate, Lordship. And also Honorable Court directed give to the basic scale of UGC scale of pay, Lordship.
No, here it is limited. The prayer is limited. Why should we go
Lordship,
into that
Lordship.
aspect? No?
Lordship. It is an admitted position, Lordship. It is a
Read
conditional
in the
appointment.
nature should not be issued directing the way to pay the UGC pay for the
Lordship.
post of the year to the post from the date of regularization. Heard, Mister?
Even Lordship 1998 UGC regulation. 1998 UGC regulation we have. If Lordship peruse, then I can apply it also, Lordship.
You just give it to me.
Lordship.
Your Lordship, there's a specific
Huh?
letter from the Director of Higher Education Assam. Your
Give it to me.
No more.
Now, Mr. Gogoi,
Lordship.
tell me one thing. Here, if you see this 2007th of February 2014. 2014. That is Annexure 4, page 15.
Page 50, Lordship.
15.
15, Lordship. I have seen, Lordship.
Now, this is for between 24/12 to 98 to 13/1/2000.
Lordship, their particular exemption was issued, Lordship, 7/4/2024, Lordship, on the basis of the UGC's 474 Lordship resolution. That resolution has said that, Lordship, the persons who have acquired the MPhil, Lordship, they are not required to obtain the PhD degree, Lordship.
Now, what do you say about the penultimate paragraph? In view
Lordship,
of
I
the
have seen
above?
this is not applicable here, Lordship. This is done in respect of the Provincialized College 2011 Act. That act was already struck down due to the, Lordship, it's, Lordship, as a unvalidated act, Lordship. And, Lordship, state government cannot derogate the, Lordship, the standards fixed by the UGC, Lordship. Time and again, Honorable Apex Court reiterated.
Now, what is this which has happened with the Deputy Secretary of Higher Education? Have a look at these documents.
Lordship, I have seen. That will not do, Lordship. We
No,
cannot
no,
do.
no, no, no. These
I
documents.
have seen.
Now, what are these documents?
Lordship is inviting
Regarding
appointment letter, sir.
appointment
I
which
am
have been
directed to
denied.
enclose a copy of the endorsement of judicial department. Advisor Education Assam regarding exemption, how they can do, Lordship? They cannot, Lordship. The statutory prescription prescribed by the UGC, Lordship. And here case is the Lordship conditional appointment, Lordship. It is not a case that, Lordship, they have not accepted the condition stipulated in the particular, Lordship. Even, Lordship, the resolution taken by the UGC, Lordship, where they have taken 474 resolution, Lordship, where they have taken a decision regarding exemption of the net and slate, Lordship. That was interfered by the Honorable Apex Court, says that, Lordship, UGC is not the authority to exempt it, Lordship. The central government is the authority, Lordship, and UGC is bound by the direction given by the central government, Lordship. It was decided in P. Sushila's case. In Lordship permit, I can place the judgment also, Lordship.
Please do. Where is it?
Lordship. Paragraph 12.
Let me deliver the judgment now.
Lordship.
You find out that for the next one.
Lordship, I have.
Lordship, time may be granted for my senior is in actually has a matter in Supreme Court today, so kindly cannot appear today, Lordship.
Heard Mr. Swansea, the learned counsel for the petitioner.
For this Friday, your
Mr.
Lordship.
K. Gogoi appears on behalf of the Higher Education Department. And Mr. A. Samu appears for the Universities Grants Commission. The case of a petitioner herein is that the petitioner had passed her MA in English by securing 56.81 marks in MA. And as such claims that she fulfills the norms of UGC, that is 55% marks. Pursuant to an advertisement dated 18/8/1997, issued by the Moriani College, the petitioner applied for the post of lecturer in English and gave interview on 10/9/97 before the selection board, and she was duly selected for the said post. The petitioner, the governing body of the said school college, thereafter issued a letter dated 15/10/1997 to the petitioner, intimating that the petitioner was appointed as a lecturer in the Department of English purely on temporary bracket ad hoc basis at a consolidated fixed pay of ₹1,000 per month. The petitioner thereafter joined on 16/10/1997. It further transpires from the records that one Sri Binod Kumar Gogoi, who was the lecturer of Moriani College in English, retired on 3/10/2012. Upon his retirement, a vacant sanction post came into existence. The Director of Higher Education, Assam, thereupon issued a communication dated 10/10/2012 to the principal of Moriani College, intimating that there is a revision in the government OM number B bracket 2 H dot 97/2003/98 dated 17/7/2004 clause 4B to regularize the services of non-sanctioned teachers again valid sanctioned post in the particular department if the teacher concerned has been selected by observing all procedure, that is advertisement, selection, governing body resolution and appointment, etc. It was further mentioned that the petitioner, from the records it could be learned that the petitioner was working as a lecturer in the Department of English since 16/10/1997 against non-sanctioned posts. Under such circumstances, the principal, Moriani College, was directed to take necessary steps for regularization of the services of the petitioner if she had been appointed against non-sanctioned posts after observing all necessary formalities. It appears on record that on 10/1/2014, the petitioner's services were regularized with immediate effect, subject to the terms and conditions mentioned in the said order.
Then Lordship, I can point out one thing also, Lordship.
Clauses 2, 3, 4, and 5 of the said order of regularization dated 10/1/2014 being relevant is extracted herein under. The petitioner accepted the said regularization order thereupon, the petitioner submitted various representations. In the meantime, accepted the said regularization order without any demur. DEMRR. Subsequent thereto, on 7th of February 2014, the Commissioner and Secretary to the Government of Assam Higher Education Department had issued an office memorandum wherein there was a reference made to the provision of Section 4(3) of the Assam Venture Education and Educational Institutions bracket Provincialization of Services Act 2011. And the decision to consider the assistant professors of librarians who were appointed by the college authority of the governing body of the colleges between 24/12/1998 to 13/1/2000 as qualified, exempting them from MPhil, NET, SLET, PhD qualification if they were otherwise qualified as per the UGC qualifications required. It may at this stage be relevant here to mention that the said act, that is the Assam Venture Educational Institutions bracket Provincialization of Service bracket close Act 2011, have been subsequently was held to be ultra vires, isn't it, Mr. Gogoi? By this court. It further appears from the records that the petitioner kept on requesting the president as well as the director of higher education for the UGC scale of pay. And the same having not been given to her, the petitioner has approached this court with a limited prayer, thereby directing the respondents to pay the UGC scale of pay for the post of assistant professor to the petitioner from the date of regularization of service, that is 10/1/2014, to the petitioner along with all admissible allowances. Full stop. From a perusal of the writ petition, there is no challenge to the conditions 3, 4, as well as 5 of the order of the regularization order dated 10/1/2014. Next. It further appears that the respondent number 3, that is the director of higher education, had filed 2 affidavits. The first of such affidavit is dated 23/2019. Wherein there was mention to made to the OM dated 17/7/2014, where it has been mentioned that the teachers working against non-sanctioned posts who would be adjusted against vacant sanctioned post will be required to qualify in the net SLET within 2 years, if they do not possess the same already. It has been further mentioned that the said OM had also clarified that if they do not possess the same within the stipulated time, their services would be discontinued. Until then, they will be entitled to basic pay only from the date of approval of the Director of Higher Education. Reference was also made to the judgment and order dated 23/9/2016 passed by this court in WPC number 3190/2012, whereby the Assam Venture Educational Institution bracket Provincialization of Services Act 2011, amended in 2012 and 2013, was declared to be unconstitutional, and the government of Assam had also repealed all rules, orders, notifications issued under the said under the, what is that act now? New act? Oh, get it from the library. Library doesn't have. Then go to the vendor and ask somebody to buy it. How do you expect this code to function without the educational manual? When this court is taken up education matter? Yes, Mr. Gogoi, what is this new act of provincialization Act
Assam
of
Bhensa
2017?
Assam Bhensa Education Institution reorganization of, I will give the name.
Of 2017. Oh, no. And issued under the Assam Educational bracket provincialization of service of teachers and reorganization of educational institution bracket comma Act 2017. It was first stated that the petitioner had no requisite norms for appointment of assistant professor as per the UGC guidelines and orders issued thereunder. Mr. Ugoy, what do you say about the last line of page 3?
Okay, is there?
The last line of page 3 of your affidavit.
Page lordship is answered by this lordship. 1988 UGC regulation lordship is 55% of. Sir, I want deduction. Lordship, this is 1988 UGC regulation lordship, lecturer lordship. At a post of lecturer lordship.
So that is the net was there.
Net was there.
This is 1998.
1998.
But what do you say about 1988?
1988 also lordship, there is a lordship requirement of net and slate lordship.
No. Here kindly come to page 3 of your affidavit.
Page 3 lordship.
Yes, the first affidavit.
Page 3 lordship.
Ah.
It should be lordship 1980. Page 3. Lordship.
It is also stated that the petitioner had no requisite norms for appointment. Do you see that the last line, page 3?
Page 3, Lord.
For appointment of assistant professor as UGC guidelines and orders issued thereunder, and the requisite norms for appointment of assistant professor in a degree college on or after Iman is 55% in master degree.
Lordship.
So if that is so, he had 56.
Regarding percentage of marks, we have no objection, Lordship.
Then?
Only the net slate part, Lordship.
But where do you have not mentioned about net?
Lordship, in a second affidavit, we have clarified, Lordship. Second
So,
affidavit.
Lordship, in the judgment para 4, it
Second
clearly
affidavit.
written, at the time of his appointment, the petitioner had postgraduate MA in philosophy, securing 52.62 marks.
I mentioned it. Para 1 of your petition, the para 2 of your petition, you have stated.
In the Gangaram, in the Gangaram Kupan, there also NAT was not there.
Yes, which portion of your affidavit?
Lordships, in our second affidavit, we have clearly stated regarding net slate part, Lordship.
Where is it?
In paragraph 7, Lordship, page 4, Lordship.
But this only has come into after 1998.
Lordship.
But she was appointed in 1997.
Lordship, he was a regularized Lordship as per Lordship 2017-7 2004 OM Lordship. The condition is stipulated therein, Lordship. He should be adjusted in the vacant sanction post and he should be completed, Lordship, the net and slate within a period of 2 years, Lordship. It is a conditional appointment. It is not a fact that, Lordship, where he is appointed. He is originally appointed non-existence post, Lordship. He is appointed, Lordship, against a non-existent post, Lordship. And his regularization was by way of office memorandum, Lordship, 77/2004, although it is a violation of the Honorable Apex Court full bench judgment, Lordship.
Which
Constitutional bench judgment, Lordship. By violating the constitutional bench, I can say that Lordship, by violating the principles of law laid down by the constitutional bench judgment, Umadevi Lordship, that particular OMS Lordship issued by the government of Assam. Even my lord judgment also reflected that things, Lordship.
Which one?
My lord Robin Samar's judgment, my lord
No, no, no,
categorically
no,
stated.
no.
Uma
OM
Devi,
of
Lordship.
2014.
Lordship.
Oh,
Lordship. Because Lordship, he is adjusted Lordship as per the office
Mr.
number 77
Gogoi.
2004 Lordship.
Mr. Gogoi,
Lordship.
if you see the Supreme Court judgments, it is clear you cannot legalize
Lordship,
an illegal appointment.
Lordship, we are doing that by way of 77 2004 OM Lordship.
Whatever may be, you
Lordship.
are not only doing that, you are doing many other things
Lordship,
as
Lordship.
regards this. How
Lordship.
can you help it?
Lordship, now he is a conditional appointment Lordship as per 17/7 2004 OM Lordship. And the condition is, one of the condition is that Lordship, he should acquire net and slur in a period of 2 years.
Last line too. Appointment of the assistant teacher as per the UGC guidelines and orders issued thereunder, and the requisite norms for appointment of the assistant professor in the degree college on or after 1/1/1989 is 55% in master degree level. Further to that, it was also mentioned that the petitioner herein was appointed on 15/10/1997 by the secretary of the governing body. And at that time, the required UGC norm was 55% in master degree with net/MPhil/PhD degree. And as the petitioner did not fulfill the required condition of net/MPhil/PhD degree, and hence the claim for regular UGC scale of pay is not tenable in the eyes of law. Subsequent thereto, the Director of Higher Education had filed another affidavit in the said affidavit. It was mentioned that the petitioner was appointed as a lecturer in Moriani College in the English department by the College Authority in 1997 against a non-existent post / non-sanctioned post purely on temporary (ad hoc) basis. The office memorandum issued on 17/7/2004 by the Higher Education Department as a one-time measure took steps for regularizing the services of lecturers working in non-sanctioned posts in the different deficit granting aid colleges by way of adjustment. This one-time measure was intended to address the grievances of a specific group of lecturers under specific certain terms and conditions laid down in the office memorandum dated 17/7/2004. It was mentioned that the terms and conditions laid down in the office memorandum dated 17/7/2004 were mandatory in nature. Further to that, it has been mentioned that it was in terms with the office memorandum dated 17/7/2004 that the petitioner's services were regularized by an order dated 10/1/2014, thereby incorporating various terms and conditions. It was mentioned that as the petitioner did not have the requisite UGC norms at the time of her appointment / regularization, and hence her services was regularized in the fixed pay of rupees 8,000 per month. And the condition for clearance of net/SLET is in conformity with the UGC guidelines, and therefore the petitioner is not entitled to get the regular UGC pay scale. The Learned Counsel appearing, I have perused the materials on record and heard the Learned Counsel for the parties. The Learned Counsel appearing on behalf of the petitioner had submitted that there are certain steps being taken by the Deputy Secretary to the Government of Assam, by the Higher Education Department, as regards the exemption of the condition of NET, SLET, MPhil, PhD to a section of college teacher appointed before 24/12/1998 in provincialized colleges of Assam. And there was a request made to the Director of Higher Education to furnish details of such assistant teachers of provincialized colleges of Assam for further action in terms with the communication dated 4/9/2019. It further appears, the Learned Counsel further submitted that the Director of Higher Education thereupon, by the communication dated 4/11/2019, had requested the principal of all provincialized colleges to submit details of the assistant professors working from before 24/12/1998 against sanctioned post in fixed pay at the rate of 8,000 regarding exemption of the condition of NET, SLET, MPhil, PhD within 30th of November 2019. The Learned Counsel for the petitioner further submits that in pursuance to the same, the principal of the Moriani College has forwarded the name of the petitioner.
Lordship, in this letter, Lordship, my Lord may kindly peruse working from 24/12/1998
I have understood, Mr.
against
Gogoi.
the sanction post, Lordship.
I have got it.
And Lordship, that was also cannot be done. My Lord may kindly peruse the P. Susila judgment, paragraph 8, 9, and 12, Lordship. I have given Lordship that.
On the other hand, Mr. K. Gogoi, the Learned Counsel appearing on behalf of the Higher Education Department, has submitted that the regularization order of the petitioner was conditional. And it was in terms with the conditions it was the requirement that the petitioner has to qualify NET, SLET or PhD within 2 years from the date of the formal approval of appointment. Full stop. The petitioner, as of now, as per his instruction, the petitioner, having not completed the NET, SLET or the PhD, having not qualified NET, SLET or has PhD, cannot be entitled to the UGC norms. He further referred to the communication dated 4/11/2019 issued by the Director of Higher Education, which specifically mentioned that assistant professors working from before 24/12/1998 against sanctioned posts. And as the petitioners admittedly was not appointed against the sanction post. The question of the petitioner getting any benefit from the recent decision of the government does not arise. I have given my anxious consideration to the matter. A perusal of the order dated 10/1/2014 by which the petitioner's services were regularized against the sanction post is a conditional order wherein it is mandated that the petitioner has to qualify for net/SLET or the PhD within 2 years from the date of the formal approval of the appointment. This aspect of the matter is mandated on the basis of the office memorandum dated 17/7/2004. 14, na?
17/7/2004.
Four. Which is the decision of the government to regularize such services only on the basis of acquiring the UGC norms. It further appears that there is no challenge to the terms and conditions, the conditions which have been mentioned in the order dated 10/1/2014. Under such circumstances, the said order, under such circumstances, till the said conditions remain in the order of regularization dated 10/1/2014. The question of the petitioner getting the UGC scale does not arise unless and until the petitioner qualify for net/SLET or has the PhD degree. Consequently, this court does not find any merit in the instant writ petition, for which the same stands dismissed.
I can even point out Lordship, one thing also, Lordship.
Yes.
The very regularization adjustment was also itself violating the Honorable our High Court's order, Lordship. Honorable High Court's order says that it's amount to contempt by our authority, early authorities. Honorable High Court says that, Lordship, the persons whose names were figured, they are entitled for the regulation. The persons who
Mr. Gogoi
that was not there, Lord.
will hear that
Lordship.
in respect to the other matter.
Lordship. Lordship. Oblige, Lordship.
The PhD degree by Magadh University, Portia on 13/8/2014.
Paragraph 6.
6.
Yes, with regard to the statements made in paragraph 5.
6 months. In paragraph 6 of the affidavit in opposition filed by the principal.
By
Given
the
yes
principal.
of the principal.
Okay.
There are 6.
Hmm.
It says that the petitioner was awarded PhD degree by Magadh University, Portia on 13/8/2014.
So you have the PhD
As
now.
per, but however,
Lordship, all the PhD degree obtained by the Magadh University, Lordship, the cases we have already granted to Lordship, they are violating the UGC regulation 2009, Lordship. There was no course work, Lordship. There was no, Lordship, regarding entrance, nothing was there, Lordship. Even the person, only 13 days, one of the example is there, only 13 days, one of the persons from the Assamese obtained the PhD degree. Only 13 days from the registration, Lordship. In another is only 1 year, Lordship. Less than 1 year, all are obtained PhD degree. They are all the scrutiny and
No, has the government passed an order
Lordship.
that we are not going to recognize the Magadh
Lordship,
University?
already, Lordship, in that particular persons, those who have obtained the PhD degree from the doubtful way, Lordship, already Government of Assam Higher Education Department constituted a high-powered committee, Lordship. Already high-powered committee has, Lordship, verified all the document and they have found that, Lordship, most of them are, Lordship, doubtful, Lordship.
But
They are
have
not
you taken into account the petitioner's case?
petitioner's case, Lordship, here it is in the, we replied, Lordship, as per their writ petition, Lordship.
Understood, but it is an affidavit which was filed as
Affidavit
far
by the
back as in
principal's lordship,
2019.
it is better principals have to know lordship, he have to lordship, produce the documents lordship.
Huh?
He have to produce the documents lord, principals have to produce the document regarding lordship, whether it is by fulfilling the UGC regulation 2009 or not lord.
No, you have to take a call as
Lordship.
regards paragraph number 6. If you don't take a call, he is duly qualified.
Lordship.
Then?
If lordship, his degree is valid one lordship, then he will definitely get the UGC required scale of pay from the obtaining the date of the lordship, PhD degree lordship. But it should be by way of the high powered committee, it should be placed before the high powered committee, whether it is lordship proper or not lordship.
No,
And-
are you placing everybody's case to the high powered committee?
Lordship, the persons.
No, not of Magad, anybody.
Anybody lordship, not only Magad University lordship, the persons who have obtained the PhD degree from the outside universities lordship.
So we take it as your submission that in case you find that his credential as regards the PhD is correct,
Lordship.
you are going to give his scale from the date on which he has got the PhD.
Lordship.
And dispose it of on the basis
Lordship.
thereof.
And my lord, may
We have only limited, our
Yeah.
limited prayers only with regard to the increment.
That is whatever may be.
Otherwise-
You have not been given the increment only because you don't have the PhD. Now you have a PhD which is there. So you take a decision on the basis that
Lordship may
along
give a
with the-
direction to the direction to the petitioner lordship. He can by way of a petition lordship, he placed the PhD degree from the authority, and authority will place it before the high powered committee lordship.
within 2 months.
Lordship may in that particular lordship may dispose of. I have no objection. If he is the valid degree lordship, he will entitle from the date of lordship entitlement lordship.
One more submission. my lord. If my
Otherwise,
regular-
lordship, the conditional appointment, the condition is there, lordship. He has not fulfilled the condition till
But
today.
not
my lord,
fulfilled.
the
He has
condition was kept
fulfilled
in
it.
abeyance, my lord, by the order dated 3/7/2003.
No, Mr. Counsel,
My lord.
you have got your PhD. Without the PhD, you are not entitled to. There is no quarrel with that proposition. Now, with the PhD which you have got in the year 2014, let me direct you to place the PhD along with the certified copy of the order, the degree, along with all the whatever documents they call to this to the higher education department, so that they can take a call within a period. And in case it is found that the PhD degree, there's no problem with that, you will be entitled to the benefits from the date you have got the PhD degree. I think that is it. Anything, you can't get anything more than that. Heard, Mr.
M. Smith.
Your name?
M. Smith. M. Smith.
Friends for the learned counsel appearing on behalf of the petitioner. Mr. A. Gogoi appears on behalf of the higher education department. And who appears for the principal?
Principal.
Mr. H. Das appears on behalf of the principal. Appears on behalf of the Bozali College, which is the respondent number 4. It is the case of the petitioner that pursuant to an advertisement dated 31/5/1999, issued by the principal Bozali College, Patsala,
Then lordship, we have filed the affidavit in 2017 lordship.
the
Before
petitioner, having the qualification of Master in Arts English, participated in the selection process and was recommended by the selection committee for his appointment to the post of lecturer of English. Pursuant thereto, the governing body of the Bozali College, that is the respondent number 4, by the resolution number 6, dated 1/5/2000, appointed the petitioner the director of higher education, Assam, by an order dated 1/8/2000, approved the appointment of the petitioner subject to 2 conditions. Firstly, the appointment of the petitioner was made subject to clearance of the net slat. Until such clearance, he would be treated as a probation. Secondly, the petitioner would draw salary at the minimum scale of rupees 8,000 per month and other allowances as per the rule. However, no incremental benefit will be allowed during such probationary period. The petitioner accordingly joined the post of the lecturer of English in Bozali College on 2/8/2000. It further appears that subsequently, one Sri Ramesh Naresh Sharma, the Vice Principal and Head of the Department of English of Bozali College, who was on lien for a period of 2 years, with effect from 1/7/99 to 36/2001, did not join his post in the college in time and neither applied for extension of the lien. And as such, the governing body of the Bozali College adopted resolution number 9 dated 17/8/2002 to terminate his services. On the same date, by resolution number 10 dated resolution number 10, the governing body of the Bozali College appointed the petitioner as lecturer in English in the college on 2/8/2000 against the lien vacancy of the Ramesh Narayan Sharma on regular basis. The said resolutions were duly forwarded by the principal Bozali College, Kotsala, by the letter dated 2/9/2002 to the Director of Higher Education, in pursuance to which an order dated 27/11/2002 was issued by the Director of Higher Education, thereby approving the above resolution and appointing the petitioner on regular basis against the vacant post arising in the college due to the release of Sri Ramesh Narayan Sharma. However, the said regular appointment of the petitioner was again subjected to 2 conditions, which was similar to the conditions as set out in the order dated 1/8/2000 by the Director of Higher Education. The petitioner thereupon, by the communication dated 3/7/2003, requested the Director of Higher Education to regularize the services of the petitioner with effect from 1/7/2001, the lien of Sri Naresh Narayan Sharma having expired on 30/6/2001. The Director of Higher Education, by the order dated 10/7/2003, approved the regularization of the services of the petitioner with effect from 1/7/2001, thereby modifying the earlier orders dated 27/11/2002 and 18/2/2003, which were also ordered to be kept in abeyance. It may be relevant to mention herein that the orders dated 27/11/2002 and 18/2/2003 there were the conditions of clearing the net oblique slab were imposed upon the petitioner. Thereupon, the record for the reveals that the petitioner was paid increments with effect from 1/7/2002 After completion of 1 year regular service by the petitioner as lecturer of English in Bozali College, Patsala, reckoning 1/7/2001 as the date of joining of the petitioner in regular service, and thereafter he was extended the benefit of increment on per annum basis. The pay scale of the petitioner was also revised as per the UGC regulation dated 30/6/2010 in pursuance of the petitioner's submission of Form 1 bracket Roman 7 bracket 4 on 13/8/2010, which was duly signed by the drawing and disbursal officer, that is the principal of Bozali College. However, by the communication bearing the communication dated 11/8/2011, the principal Bozali College informed the petitioner that the incremental benefit salary cannot be paid to him with effect from July 2011 until the validity of the order dated 10/7/2003 issued by the Director of Higher Education is settled by the Director of Higher Education, Assam. Subsequently, the petition however, the petitioner was shocked to receive a communication dated 11/8/2011 issued by the principal Bozali College, wherein a reference was made to a communication issued by the Director of Higher Education dated 29/7/2011. It was mentioned in the said communication dated 11/8/2011 that the incremental benefit of salary cannot be given to the petitioner from the month of July 2011 until the order dated 10/7/2003 is settled from the Director of Higher Education's end. It is relevant to take note of that by the communication dated 29/7/2011, the Director of Higher Education requested the principal of Bozali College to submit circular/order issued by the government allowing regular scale of pay without clearing net/SLET/MPhil or PhD, as was allowed in the case of the by granting him the UGC scale of pay by preparing IPS with effect from 1/1/2006 with incremental benefit, though the petitioner had not cleared the net/SLET/MPhil or PhD. The respondent number 4 was further directed to submit another proposal to allow regular UGC scale in respect of another teacher. Further to that, it was also mentioned the principal of Bozali College was show cause as to why disciplinary action should not be initiated against him for his irregular activities in connection with allowing regular scale of pay to lecturer without government prescribed norms. Mr. Counsel, tell me one thing, and you also, Mr. H. Star, you tell me one. In your affidavit, you say that the petitioner got his PhD in 2014. Why in your communication of 2015, there is no mention of that, which have been enclosed as Annexure 13 to the writ petition? Huh?
Not any.
What do you have not annexed? I hope you have a copy of the writ petition.
Even Lordship, in the writ petition, not a single pair is there, Lordship, not a single word is there, Lordship, regarding obtaining PhD degree. Although the petition was
And
filed
it
in
is surprising
2016, Lordship.
why the writ petition was filed in 2016. There is no mention of the PhD.
In all likelihood,
If you have got in the year 2014, why there is no mention? And the only hurdle was that. Then
it was not annexed, it was not filed during that point of time.
What?
It could not be filed during that point of time.
what couldn't be filed? Are you not aware of getting a PhD?
But at that time, while filing, our instruction was not there.
No, not forget about the instruction. I hope you have filed it on the basis of instructions by the council, by the petitioner. Why the petitioner in the year 2017 or 16 did not inform you that he has got a PhD in 2014? And why in this communication of 31/12/2015, there is no mention by the principal that he has got a PhD? And why this communication of 31/12/2015 is in reply to a communication of 2011? Either this document is fake or fabricated. Annexure 13.
All are doubtful, Lord. If Lordship, he has genuinely he has get the PhD, Lordship, definitely he will, Lordship.
Definitely.
Lordship.
It, however, is relevant to mention, as could be seen from a perusal of the writ petition, that in pursuance to the order, in pursuance to the communication dated 29/7/2011, the principal of Bozali College, Patsala, on 31/12/2015, had clarified as regards the office order dated 10/7/2003, as well as the communication, as well with reference to the communication dated 29/7/2011. In the said communication, there is no reference, however, there is no reference in the contents of the said communication that a petitioner had got his PhD. However, it is relevant to take note of that in the heading of the said communication, there's no mention of here, that the petitioner have got any PhD. It further appeared that the petitioner also submitted another representation to the Minister, Education, on 4/2/2016. There was no mention whatsoever that in the meantime the petitioner had got his PhD. The writ petition thereupon was filed by the petitioner, challenging the communication dated 11/8/2011. And with a further direction to the respondent authorities to release the annual increments due to the petitioner with effect from July 2011, along with all consequential benefits admissible to the petitioner. From the records, it reveals that the said writ petition was filed on 31st of August 2016. This court, by an order dated 8/9/2016, issued notice it reveals from the records that the Director of Higher Education had filed an affidavit on 21/3/2017. In terms of the said affidavit, it was the specific stand of the Director of Higher Education that the clearance of net/SLET have been mandatory as per the UGC Regulation 2000, who have joined in the service after 24/12/1998. It was further mentioned that as the petitioner had been appointed after 24/12/1998, the petitioner will have to clear net/SLET/MPhil/PhD, as the case may be, as per the UGC guidelines. Until the clearance of the above mentioned eligibility criteria, the petitioner will be given the fixed salary without incremental benefits. Next, the respondent number 4 had filed his affidavit on 24/2019. In paragraph number 6 of the said affidavit, it has been mentioned that the petitioner was awarded PhD degree by the Magadh University, Bodh Gaya, on 13/8/2014, and thus fulfilled the criteria for getting regular UGC scale of pay (bracket in lieu of net/SLET (bracket close). It was also mentioned that the matter of granting regular UGC scale of pay to the petitioner have been pending in the Office of the Director of Higher Education by file number GB/AC withdrawal/376/2014. and the petitioner have not been given the regular UGC scale of pay till date. This court have perused the materials on record and have also heard the learned counsel at length. It have the question of admittedly the petitioner was appointed after 24/12/1998. And in terms with the UGC notification, which relates to pay scales, minimum qualifications for appointment of teachers in universities and college and other measures for the maintenance of standards 1998. It has been mentioned in clause 4.41 that the lecturer, for the post of the lecturer, the person has to have good academic record with at least 55% of marks or an equivalent grade of B in 7-point scale with letter grade O, A, B, C, D, E, and F at the master's degree level in the relevant subject from an Indian university or an equivalent degree from a foreign university. It has also been mandated that besides fulfilling the said qualification, the candidates should have cleared the eligibility test, (NET), for lecturers conducted by the UGC, CSR, or similar tests accredited by the UGC. It, however, surprises this court to take note of that, of the contents of paragraph number 6 of the affidavit filed by the respondent number 4. Wherein it has been mentioned that the petitioner was awarded the PhD degree on 13/8/2014. If that be so, why the petitioner has been completely, why the petitioner have not mentioned about the same in the writ petition which was filed in the year 2016? Or as to why in the communication dated 25/31/12/2015 issued by the principal of the respondent number 4, Annexure 13 to the writ petition, there is not a single mention that the petitioner had obtained the PhD degree. Be that as it may, one aspect of the matter is clear, that if the petitioner has a PhD degree, from a recognized university, the petitioner would be entitled to the due increments as sought for in the writ petition. Consequently, this court therefore however, consequently, this court therefore taking note of the fact that there was no mention of the PhD degree by the petitioner, in his writ petition, and it is only the respondent number 4 who had, by way of an affidavit, stated that on 13/8/2014, the said PhD degree was obtained by was awarded to the petitioner. This court is of the opinion that the interest of justice would be met by disposing of the writ petition with the direction to the Director of Higher Education to verify as regards the authenticity of the degree, authenticity of the PhD degree obtained by the petitioner on 13/8/2014 as stated by the respondent number 4 in his affidavit. It is further directed that in the circumstances it is found that the petitioner's degree is authentic, and is in accordance with the UGC regulation, then in that regard, the Director of Higher Education shall grant the petitioner the increments to which he would be otherwise, to which he would be entitled to from the date of the said degree, PhD degree awarded to the petitioner. The petitioner herein is directed to submit the certified copy of the instant order along with such documents, along with the credentials of his degree, of his PhD degree, dated 13/8/2014. To the Director of Higher Education within a period of 30 days from today. And thereupon, the Director of Higher Education shall take appropriate steps for necessary verification.
My lord may also indicate to place the before the high court committee which was constituted for the validity of the plea.
Make the necessary verification
Lordship, Lord.
as required. And either through its own office or through the high power committee.
Lordship.
And thereupon, if it is found that the petitioner's degree is authentic, the PhD degree of the petition is authentic, the petitioner be granted the benefits of increment from the date of the said PhD degree awarded to him. The said exercise be completed by the Director of Higher Education within a period of 2 months from the date the PhD degree, along with the certified copy of the instant order, The credentials of the PhD degree as well as the certified copy of the instant order is served upon the Director of Higher Education.
Item number 4.
Yes, Mr. Gogoi, you
Lordship.
take all these things.
Lordship.
This judgment is not reported. Robinson, I think it's report.
Lordship.
Item number
Four.
4. Yes.
That's
Why
okay,
is it 4
instructions,
here?
my lord,
2015 matter. Good. What instructions are here? What is your matter, Mr. Datta?
Lord, the petitioner was Lord working in a school, my lord, which was amalgamated with the high school, my lord.
Ah.
Lord, one of the condition of the amalgamation was that, my lord, they will be entitled to the graduate scale of pay, my lord, if he is having graduate degree, my lord. Now, my lord, there is a provision under the section, my lord, rule 3, my lord, of the Assam Services, my lord, Provincialized Service Rules 2003.
Just 1 minute. You are asking for grant of graduate scale of pay to the petitioner from the date of amalgamation of the school with so and so and read in the nature of services, setting aside the order passed by the secretary to the government of Assam, read in the nature for OM, setting aside the OM. Yes.
But initially, I paid for my lord upgradation of course. So that was rejected by saying that this policy has been withdrawn. Then thereafter, there is a similarly situated case, my lord. Lordship will find at page 30. My lord, the scale was given, the graduate scale was given. So I filed this case, my lord, saying, my lord, that this will also do, my lord. Of course, this person is in the middle retired, my lord. So the only thing he can get is the scale. That is at page 30, my lord.
You are challenging which order?
The order which has been challenged is page 25, man, where my lord case for my lord upgradation has been rejected. Annexure 7, page 25. By holding my lord, the policy of upgradation has been discontinued.
So this has been done in view of the office memorandum dated 18/11/2011.
Much later, my lord.
Where is it?
Well, that has not been an next, my lord, though it has been said to be next, my lord, in with this
You are
particular order.
challenging this office memorandum. They are doing it entirely on the basis of the office memorandum.
My lord, my case is therefore, my lord, in this that was with regard to upgradation of the postman. Now, what I'm saying, my lord.
So you have this office memorandum, you have no quarrel.
My lord, I am saying that the scale is granted, my lord, as in the similar case, my lord, page 30.
No, Mr. Datta, this court doesn't grant similar cases.
No, I understand, my lord. I understand, my lord. But then, my lord,
You have to
even if
first
it's
make
office
out of
memorandum, my
your
lord,
case that it comes within the ambit of.
my lord, my case would be, my lord, first of all, my lord, I was, my lord, the school was provincial in 2006, my lord. So this withdrawal order, my lord, came much later, first of all, my lord. Secondly, my lord, if one goes to the rules, my lord, the secondary education provincialized service rules 2003, my lord. Section rule 3 is very specific, my lord. All those teachers, my lord, who are having graduate scale, my lord, or graduation, my lord, they will be automatically
This
upgraded.
rule is of which year?
2003, my lord.
Okay.
That
Then-
also feel, my lord. So that particular, my lord, section 3, my lord, I have specifically relied upon that also, my lord. Section 3, rather rule 3, my lord. Rule 3 specifically says, my lord, that those, my lord, who are not my lord, having graduate degree, but my lord, were working in junior posts, my lord, they will be, my lord, automatically upgraded in the vacancies that arise. So that rules, my lord, that has not been, my lord, that has not been, my lord, that has been set aside, my lord, not that has been, my lord, amended, my lord, or repealed. My lord. So therefore, this rule holds the field. And my lord, so far as the scale is concerned, my lord, therefore, my lord, since a similarly situated person, they have also granted this pay scale to other person also, my lord. After this court's order, my lord, they've granted this pay scale, my lord, to the other person. Now, this was, my lord, discontinued with the ground, my lord, that the upgradation will not take place. The proposal for upgradation of teachers working in intermediate scale of pay, having degree qualification to post of graduate teacher in the secondary, higher secondary schools, has since been discontinued by the office memorandum dated 18/11/2011. But lordship will see my provincial as amalgamation order at page 26, my lord. Sorry, my lord, page 19, my lord, annexure 4, 26th of December 2006, my lord. In the rules, my lord, there is of course no provision for amalgamation, my lord. But this
Amalgamated could be named
6, my lord, I'm relying on specific on clause 6. my lord.
What is the meaning of this word? Without prejudice to upgradation scale of pay of teachers working in ME madrasas at intermediate scale of
Scale of it. My lord, and as per the rules, my lord, all those junior teachers, my lord, who are not having, my lord, who are having, my lord, graduation, my lord, they are going to be automatically upgrade, my lord. And my lord, as and when the vacancies arise. So this petitioner, my lord, he was working in ME school, my lord, but the requirement was of that of, my lord, graduation was not required, a requirement, my lord, of for appointment. My lord. But this person, he's in ME, my lord, he was having the graduate qualifications. So when the school was amalgamated, my lord, without prejudice to his right to get the upgraded scale of payment or, my lord, upgraded post, brother. But this upgradation post, upgradation of, my
But
lord,
where is that office memorandum?
office
Without
memorandum,
the office memorandum, Mr. Doctor, one problem
that
it
was
is,
not served, my
because
lord.
you
There was-
see, whatever may be,
my lord.
you will ask Mr. Khatonia to get hold of it, because here the order has been based on an office memorandum,
Yes, that I have seen.
and you have challenged the office memorandum. Can this court take a decision without the office memorandum?
That is brought to the record by them.
You have it,
Right now, I don't have, my lord.
obviously, right now I am,
Yes, my lord, I'll produce, my lord.
because
This is the
if
basis
the
of the
Secretary
challenge,
to
my
the
lord.
Government of Assam, Secondary Education Department has based upon an office memorandum, he has produced. But Mr. M. Datta, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Khatonia appears on behalf of the Secondary Education Department. Upon perusal of the materials on record, it transpired that the petitioner have challenged, amongst others, the order dated 16/12/2014, as well as the office memorandum dated 18/11/2011. It further transpires that the order dated 16/12/2014 was passed on the basis of the office memorandum dated 18/11/2011. However, the said office memorandum dated 18/11/2011 is not a part of the record. The learned counsel appearing on behalf of the Secretary Education Department is directed to produce the said office memorandum dated 18/11/2011 on the next date so fixed. Let the matter be listed on 26th of April 2023.
Oblige.
Oblige, Lord.
Vice 22.
Oh, the instructions were produced by Mr. N.J. Khatonia be kept on record and marked to the left.
My lord, that may be, copy may be served to me, my lord. That
Which
whatever
one?
instructions been placed today, my lord. Because maybe
This
I
one,
have to
I-
reply to that also.
To one, take certified copies. Should I mention it? The petitioner would be at liberty to take certified copy of the document marked with the letter X.
Take it.
You want that? No. It is line to be said.
Retired man, man.
So that is why you are involving this court into all these things. Get a copy, get it. Yes, madam, tell me.
Yes, Lordship, today is for status report of
Appearing on the
pension as well as
behalf of
salary
foreign
from
accommodation for
Finance
transport
Department and
at
AZ.
instructions. Yes, Mr. Finance and AE. Where is it? Oh, The finance is not there, neither the E is there. Hello, we call the director of finance, commissioner and secretary of finance to be the court as they have not appeared. Heard Mr.
B.
Houston?
Talukdar.
Yeah, Mr. P. Talukdar, the learned counsel appearing on behalf of the petitioner. None appears on behalf of the finance department as well as the accountant general AE. This court by an order dated 15/3/2023 had directed the respective departments, the councils for the respective departments to obtain instructions in terms with the order dated 17/2/2023. Taking into account none has appeared on behalf of the finance as well as the accountant general, this court fixes this matter on 12th of April 2023, on which date the commissioner and secretary to the government of Assam Finance Department, as well as the principal accountant, who is that? Senior account officer of the principal office of the principal accountant general AE shall be personally present at 10 a.m.
34.
Wait, please, your worship. This matter with regards to non-payment of areas.
You want a copy of the order? Last order? You ask the commissioner and secretary to be personally present at 10:30 on 12th.
My lord,
Yes, as none had appeared on behalf of the finance as well as the accountant. So we have asked the senior account officer as the principal.
some matter, my lord, came up before 4/7. I had to rush there, my lord.
Very well, if you have, then the finance department should engage some more councils if you have too many matters. You can't help it.
Lordship, I can kindly consider for today, my lord, for this matter.
Well, you got your instructions why the area salary has not been paid for such long?
My lord, the instruction is that, my lord, the area salary, it is required to be dealt with, my lord, by the administrative department concerned. Only in case of, my lord, dearth of fund, if there is any paucity of fund, then if any proposal is moved to the finance department, then, my lord, the finance department takes a call. Otherwise, my lord, finance department has no role.
No, here, earlier, cases, no? This court made a base categorical direction on the last occasion for the council for the finance as well as the accountant general to obtain instruction
Yes, my lord, I have
in
obtained,
terms with the order dated 17/2/2013.
absolutely correct.
Now, this is a case where the payment has not been made by you are this person was working in the finance department.
Yes, Lordship.
Yes. And then why the finance department has not done it? Are you not the department?
Yes.
Then what type of instructions you have got?
No, my lord, it comes under the, my lord,
No, this is
putting
no
the
teacher business.
administrative control of, my lord.
No control of anything. This is the finance department.
Yes, my lord.
Then all respondents are finance department. Then there is no other authority. This person concerned have not received his area salary from 1997 to 2000.
Lordship, may kindly peruse these instructions, my lord.
Yes. Yes, Accountant General, what is the status of the pension of the petitioner?
Lordship. Lordship, first of all, Lordship Department has to forward the pension
So
proposal.
they have not done that. Then what is wrong in calling the commissioner and secretary? When the orders passed by this court are not followed, then what is wrong with this? You come up with an instruction to the effect that this person, the department has to do it. And the department happens to be the finance department. Now, don't bring out the fact that that is the finance EC department or the finance PRU department.
Lordship will kindly, my lord, give me, my lord, some accommodation, my lord, I will come up.
For what? Tomorrow?
Yeah. Yeah.
Not got his, yeah, and the reason why he has not got is this. Madam, you have referred to a judge order passed by, is this the same petitioner? And you see, Mr. Barbujari,
My
there is already an order passed in the year 2019.
My lord.
Then why haven't you sent and why they have not received till now? A read being issued also doesn't means nothing happens to this department.
My lord, it was already forwarded to the office of the accountant general. They have, my lord, send it back. We have again sent it to the accountant general.
But they have said that they have not received.
No, my lord, Lordship will kindly see because this instruction was seen, my lord, perused by this honorable court.
No,
on
no,
an earlier-
the accountant general has put an objection out there that what to do as regards that period.
So that has been clarified, my lord, by the finance department.
But
Kindly
what have you done as regards that? Have you put that on duty? Suspension period? What have you done as regards the suspension of the petition?
that, my lord, we have.
Now he has retired long back.
Yes.
Now what have you done? Have you continued the suspension thereafter?
No, my lord, I have not.
Then if you have not done, then why you are not regularizing his pension period? Only for the purpose of pension. Otherwise, what will happen? That is the problem which he is facing, isn't it, Mr. Talukdar? That is why he is not getting it.
But my lord, Lordship will kindly appreciate, my lord, my instructions say, my lord, which I have put it across the table, my lord. It says, my lord, we had once, my lord, given the proposal, my lord, send all the papers to the office of the accountant general. It was returned with some query. My lord, we have met that query and my lord, we have sent it again to the office of the accountant general. So that's why, my lord, on the last occasion, my lord, both AZ as well as my lord, finance was directed, my lord, to seek instructions, my lord.
Yes.
Now, our instructions.
AG says that we have not received any payment. And the main problem is because you are not regularizing this period of suspension and you have not taken anything. No departmental proceeding was contained. Neither there is a department by which there is a punishment, neither you have continued. A person who has retired, when did you retire?
Retired on Lordship 31/1/2015.
See? This is the fit case where the secretary has to be.
Lordship will kindly take up the matter tomorrow, my lord. I will immediately take up the matter with the authorities, my lord.
Take up the matter and get the order of regularization of the suspension. As you have not taken, I would have otherwise, there's a different way. If you have not done anything, as regard the, he retired in 2015.
Then my lord will, Lordship will issue an order, my lord, direction to the authorities, my lord, to pay, my lord, regularize that. Lordship can adjudicate, my lord. There is no difficulty in that. But my lord, the direction to the finance on the last occasion was.
No, the accountant general have returned the file only on the basis what to do with that suspension period. Isn't it?
That period is to be regularized, Lordship, because. that
Unless
period
you
will
don't
be-
regularize, nothing is happening. And knowing fully well, now, if you have again sent it, have you regularized that period?
My lord, that is not, my lord, explicitly, my lord, mentioned in my instructions, my lord.
Mr. Barbuja, you have got these instructions of a thing of 2021.
21, my lord, I have the latest instruction on my lord, 4th of March,
Where?
my lord, another bunch of papers, my lord, which I have
There's
received.
no 4th of March business. These are of 2021.
In one another bunch of papers, my lord, which I have just tendered, my lord. But it is- This instruction, my lord, we have received, my lord, pursuant to last order dated 17/2/2023, my lord.
Now, this order is already there. Mr.
Lordship, in this case, Lordship, I have to obtain instruction, principal Lordship, please, because Ardhor was attending the court. Lordship, after some time.
No,
Lordship,
no,
I
no,
am
no. I
calling
don't believe in all these the different councils appearing on
No,
it.
Lordship,
If you
earlier
are-
also, Lordship.
Then that is your lookout.
Lordship, but Lordship, suspension period is to be regularized,
No,
Lordship.
it has
Otherwise,
been
Lordship-
already done. Be treated as duty for pensionary benefit. See this order. Show it to him. And you have only, the penalty is only for the purpose of what? What is your penalty? The penalty is only one increment. Only one increment is the penalty. If that be so, then why have you not paid him the salary for this period?
That, my lord, once it is regularized, my lord, then he will get the salary, my lord, because that period.
What is there to regularize? The only you have the punishment imposed. Punishment has already been imposed in 2008.
Yes.
The punishment imposed is only one increment is stopped with cumulative effect.
Cumulative effect. My
That
lord,
is his punishment under 7.2. So under such circumstances, why he would not be entitled to the salary?
back wages.
Or back wages. That is his salary.
Yes, salary, yes, my lord, for that period.
Yes, this is what he is asking for.
No, my lord, since we.
Other departments I would have understood. They always take the blame of that the finance department is doing, but here the finance department is absolutely in fault. And it is sorry to say that the matter has been pending from 2021.
Right, my lord, the representation which the petitioner has made before the authorities, my lord, that has been turned down, my lord.
Representation for what?
My lord, this order, my lord, of 18 November 2021, it says, my lord, peruse the representation.
Understood, but representation for what?
My lord, with regard to for review of that order, my lord.
No, you kindly see the representation, it is there
My lord,
at page 33 of the petition.
my lord.
It is in respect to this representation this has happened.
My lord.
And the punishment which you have imposed, that is, see the next order. If you require review or anything about that order, the order is clear that you only have stopped one increment. That's all.
Yes,
Then why he would not be entitled to the salary? Or is it the law that the suspension, person who have been punished, or there is a punishment? Then in that case, he would not be entitled to the period during which the suspension? No. If that be so, the order has to be clearly mentioned out there.
Yes, no, my instruction, my lord, says that he had made a departmental appeal, my lord. That is the difficulty. My instructions say, my lord, that he had filed an appeal petition, my lord. And with my lord, on 4th of,
Mr. Borpujari, forget about the appeal petition.
my lord.
Let us assume that the petition has accepted. Accepted the order of 2008. Let us assume. Can you debar him for the salary during the period of suspension? No, unless you put an order to that effect, which is not that is not the punishment.
Yes, that is not the punishment.
Now, in view of the Rule 21, you cannot again change that.
Yes, my lord. Yes, yes.
So this area salary he is entitled to
Yes,
for that period,
yes, for that period.
subject to, if there is a subsistence allowance being paid, then obviously that has to be, but otherwise he is entitled to. Now, in that order, it categorically mandates that this period is to be treated as period on duty for pensionary benefits.
Yes.
If that be so, why is the accountant general not granting the pension on that ground?
Lordship, one thing, Lordship, our name has not been shown in the cost list, Lordship. That is the problem, Lord. Pending council agree, not been shown.
Now, my lord, lordship will kindly, my lord, appreciate, my lord, the interim order of imposing penalty. My lord, it says, my lord, that is pleased to order that one increment with cumulative effect be stopped. And the period of suspension from 28/1/97 to 10/7/2000 be treated as on duty for pensionary benefits only. So he will get the, my lord, pension with regard to that, my lord, period. Now, so far as, my lord, getting the area salary is concerned, now, my lord, question is to fall, my lord, whether, my lord, if a person, my lord, who was suspended for that time, for that period, and subsequently by an order of penalty, my lord, his suspension, it is stated, my lord, it has been held by the authority, disciplinary authority, that it is to be treated as on duty. Now, for the purpose of pension, but the impugn order is silent as to whether, my lord, for that period, he will be entitled to area salary. That, my lord, can adjudicate, my lord.
Why? Now tell me one thing. Wouldn't that amount all what you are saying, amount that you are imposing a penalty during this period of suspension, which is not the penalty otherwise?
Which is otherwise not a penalty.
Then can you do that in view of Rule 9(1)? No. You have to limit yourself within the only to what is the penalty given under 7.
Yes, yes.
And the 7 is only, you have only stopped his increment. Then whether you put it on duty or no duty, that is whatever may be.
Yes.
But he would be entitled out there because of the fact that you have not done anything to that effect.
Yeah.
Without that there being an order. Why should one go into the technical aspect of the matter that he has not filed a review within 3 months or 5 months out there?
My lord, now, my lord, the issue have fallen, my lord, in two parts, my lord, Lordship will kindly consider. So far,
The issue is nothing to that effect. The issue is why he has not got the pension for the last 7 years, 8 years.
yeah, now, so far as.
We
my
are
lord,
only concerned with.
yes, now, my lord, so far as the issue of pension is concerned, definitely, is you will have to take a call.
He says that he has not got your papers. Has he got your
No,
papers?
no. Unless and until they send us the papers,
to do?
we are extending. Lordship may direct to send all the papers in full form and we'll comply within a period of 2 months.
So what you have done, you have imposed a penalty of depriving a person of his pension for the last so many years.
But suspension period as per the impugn order of penalty, my lord, it says, my lord, it is to be ticket as on duty. So meaning thereby he will not be deprived. Now, my lord, for some this reason or that reason, my lord, because that instructions, my lord, which I have placed across the board, my lord, Lordship has paroled it. Once it is sent, it was returned. It was again sent, my lord. Now,
Again, but they say that they have not received.
to that extent, my lord, Lordship will kindly grant me, my lord, sometime, my lord, with regard to this issue, my lord, whether that sent, it has been sent. And so far as area salary is concerned, but definitely is the issue of law, my lord, Lordship can adjudicate. Lordship
What
can
is there
direct-
to decide on this aspect of the matter?
Lordship will kindly grant me, my lord, at least 1 week time, my lord,
For what?
my lord, to get the updated instruction, my lord, whether
As
this
regards pension.
pension, whether the pension.
As
paper-
regards area salary, I am passing the order just now.
the area salary, my lord, along with, my lord, on the next date, my lord, Lordship will kindly, my lord.
Tomorrow,
Tomorrow, my lord, it will be
you give
difficult.
your pension and everything.
But tomorrow it will be difficult, my
Then-
lord, with all respect, my lord. Lordship
Then-
will kindly accommodate, my lord.
No,
Kindly
no.
accommodate for at least 1 week, my lord.
Why?
Let me get the instructions, my lord. Because we have already, my lord, pursuant to last order, my lord, we have.
I'm also putting you to notice as regards interest.
So my lord will kindly consider.
We're putting you to notice as regards the interest on the and to be deducted from
My lord,
the
in pursuant-
salary of the area. Heard Mr.
My lord,
P.
pursuant to
Talukdar,
last
the
order,
learned
my lord, we
counsel
have received
appearing
the
on behalf of
instructions, my
the
lord.
petitioner. Mr. R. Bopudari appears on behalf of the finance department and Mr. Ardhor appears on behalf of the accountant general A. On 17 to 2023, when the matter was taken up, the instruction produced by Mr. R. Bopudari then was that the pension papers of the petitioner were forwarded to the accountant general AE on 5/12/2019. It was further mentioned that as per his instruction, that the papers were again sent to the accountant general AE on 3/4/2021 for taking necessary action from their end after meeting their observations raised in the communication dated 5/12/2019. Taking into account that the office of the accountant general was not taking steps in for the purpose of finalization of the pension, this court impleaded the office of the accountant general AE as the respondent number 4 to the writ petition. This court further directed by the order dated 17/12/2023 to list the matter again on 3/3/2023, on which date the learned counsel for the finance department, as well as the learned counsel appearing on behalf of the accountant general AE, were directed to apprise this court as regards the status of the pension as well as regards the area salary. This matter, though, was directed to be listed on 3/3/2023, but was taken up on 15/3/2023, when both the learned counsels appearing on behalf of the finance as well as the accountant general sought for sought for accommodation for a week so that they can obtain instructions in the matter in terms with the order dated 17/2/2023. This court therefore fixed the matter today, thereby directing the learned counsel for the finance department as well as the learned counsel for the accountant general AE to obtain instructions in terms with the order dated 17/2/2023. Mr. Ardhor, appearing on behalf of the accountant general AE, submits as of today, as per his instructions, fresh proposals from the finance department have not been received. For which the pension could not be finalized by the office of the accountant general. It may be relevant to take note of that on 17/2/2023, this court requested the learned counsels appearing on behalf of the respondent finance department as regards the area salary for the period from 28/1/1997 to 10/7/2000. It is pertinent then to mention that the said period for which the area salary was sought for was the period during which the petitioner was put under suspension. The learned counsel appearing on behalf of the petitioner had submitted that by an order dated, what is the order?
14 November 2008.
8, na?
8, 2008.
14?
November 2008, Annexure 12.
Annexure?
Sorry, Annexure A, page number 12. Repeat.
Annexure?
A, page number 12.
Had submitted that by an order dated 14/11/2008, the respondent authority, more particularly the Commissioner and Secretary to the Government of Assam Finance Establishment B Department, had imposed the penalty in terms with Rule 7.2 of the Assam Services Discipline and Appeal Rules 1964. To the extent that one increment with cumulative effect be stopped and the period of suspension 28/1/1997 to 10/7/2000 to be treated as on duty for pensionary benefits only. Taking into account that the said order dated 14/11/2008 has to be taken into account for pensionary benefit, and it has been taken into account as on duty for pensionary benefit, this court sees no reason as to why the office of the accountant general AE should not process the papers of the petitioner by treating the said period to be on duty for the purpose of pension. Mr. Ardhor, the learned counsel appearing on behalf of the office of the accountant general AE, submits that the same shall be done upon receipt of the proposal from the finance department. Next. This court also finds it relevant to take note of that the penalty which have been imposed upon the petitioner by the order dated 14/11/2008 is only one increment with cumulative effect to be stopped. Full stop. The penalty so imposed does not in any manner deprive the petitioner of his salary. During the period from 28/1/1997 to 10/7/2000. This court therefore is of the opinion that the petitioner would be entitled to the salary from 28/1/1997 to 10/7/2000 after making appropriate deductions in respect to the subsistence allowance which have already been paid to the petitioner.
But if one thing,
Huh?
as per the knowledge of the petitioner, there are other 3 increments during that period. That should be considered also. After deduction of 1 increment, whatever increment.
The rest we'll take care of later. But first you have to get yourself. Taking into account the same, this court directs the commissioner and secretary to the accountant, to the office of the direct the respondent number 2 and respondent number 3, respondent number 1, 2, and 3
Yes, madam.
to take appropriate steps for releasing the area salary of the petition for the period from 28/1/1997 to 10/7/2000 after taking into account by deducting the amount which have been already paid on account of subsistence allowance. The same shall be done within 15 days, 10 days,
Well, let it be 1 month, madam.
1 month for finance.
Madam, to
I would
process,
have
madam.
understood the other departments.
Madam,
they-
we have to process, madam. Some
Within a period of 1 month from the date of the instant order. Taking into account the same, let the matter be listed again on 10th of May 2023, on which date the learned counsel appearing on behalf of the finance department as well as the office of the accountant general shall apprise this court as regards the status of the pension of the petitioner as well as to whether the area salary of the petitioner for the period above mentioned have been duly disbursed. The registry shall also show the name of Mr. Ardor as appearing on behalf of the office of the accountant general.
Unless and until
A
the
copy
send
of the order be given to both Mr. Ardor and Mr. R. Popuzari,
so long they
the
send
learned
the
counsel for doing the need.
things, the finance department, when they will send, then only we can start.
Huh?
The finance department, as and when they will send all the papers in full form, then only we can start load.
Okay, 1 line. This court puts notice upon the officials of the finance department that if there is further delay in sending the papers, this court would be constrained to impose interest upon the finance department, and the same shall be recovered from the salary of the airing officials. Now it will go.
May I pray for a copy of this order, madam?
Yes, I've already given.
Madam, I'm so obliged, madam.
Give this to Mr. Borkungal. Mr. Wyatt Manan, the learned counsel appearing on behalf of the petitioner and Ms. E. Mutari, appearing on behalf of the Education Department. No Finance, Treasury Officer. None appears on behalf of the Finance Department or call. The Learned Council appearing on behalf of the Education Department had submitted that the Governor of Assam has been pleased to sanction an amount of rupees 4 crores 9,20,708 for the payment of the area salaries of the petitioner with effect from 1/1/2013 to 28/2/2019. For payment of the area salaries of the teaching and non-teaching staff of Aymari Senior Madrasa. And the details of which have been given in the said sanction letter. It further transpires that the said amount, that there has been a budget allotment in respect to the said amount. The said document is kept on record and marked with the letter X. Taking into account that the sanction has been already granted and the budget has been allotted in respect to the said amount of rupees 4 crores 9,20,708 for payment of the area salary of the teaching and non-teaching staff of the petitioner working in the petitioner madrasa. This court therefore disposes of the writ petition with the direction for release of the said amount. Yes, Mr. B. Gogoi, how much time release?
Sanction after that, they will have to go for sealing. That period is otherwise over. So Lordship will have to give us some time, my lord.
How much?
Reasonable time. Let it be, my lord, 2 months.
2 months again. There is already a budget allotment.
Yes, my lord.
Then?
No, that will be the outer limit. It's not that we'll wait for 2 months. Then it will be paid, my lord. Otherwise, my lord, if it is sanctioned by 31st, it will go to the accountant and it will be disbursed.
Shall disposes of the writ petition with the direction to the respondent authorities to release the said amount so sanctioned within a period of 1 month from the date of the incident order. With the above the petition stands.
38.
Yes, Mr. Decker.
Pertains to non-payment of.
Yes, what instructions you have got? This is the area salary.
Yes, Lord.
is a clarification by the back.
Yes, how much time
1 month.
for
Now
disbursal?
they are processing
For disbursal,
for sanctioning lottery, and then thereafter that disbursement process.
understood, but this is a case where this has already been held. It is already, those aspects are already clear.
Lordship. Now they clear and then.
Undersecretary
clarification
had
that-
written it to the Director of Elementary Education as to whether this person was working in the sanction post during this period.
Lord.
The Director of Elementary categorically mentions that yes, he was working during this period,
That clarification was given on 24th of March, Lordship.
because you asked on 21st of February
February, Lordship.
and then on 24th of March.
Lost.
Now what else remains?
Now that process is on, so that sanction will be accorded.
Heard Mr. A. Dekar, the learned counsel appearing on behalf of the petitioner, and Mr. P. N. Sharma appears on behalf of the Elementary Education Department. It has been brought to the notice of this court that the Secretary to the Government of Assam Department of School Education had requested the Director of Elementary Education Assam as to whether the petitioner was working as the assistant teacher of Bongaigaon Vidya Mandir ME School under the Deputy Inspector of Schools Bongaigaon for the period from 8/2/2006 to 23/4/2008 against the sanctioned vacant post or not. It reveals that on 24th of March 2023, the Director of Elementary Education had written to the Secretary to the Government of Assam Department of School Education stating inter alia that the petitioner was working against the valid sanction post during the area salary period with effect from 8/2/2006 to 23/4/2008 as sought for 2008. Full stop. The Learning Council for the petition for the Elementary Education Department submits that some accommodation is required in the instant matter so that in the meantime, the sanction as regards the area salary of the petitioner can be so that the steps for sanction of the area salary of the petitioner could be taken up as well as for disbursal. Taking into account the same, let the matter be listed on 10th of May 2023. The Learned Counsel appearing on behalf of the Elementary Education Department, Mr. P. N. Sharma shall apprise the court on the next date as to whether the sanction has been granted in respect to the area salary of the petitioner and further as to when the said amount of area salary of the petitioner would be disbursed to the petitioner. The documents submitted by Mr. P. N. Sharma during the course of the hearing is kept on record and marked with the letter X.
Liberty may
42.
also be granted for-
Huh?
Liberty may also be granted for arbitration.
For?
On 10th of liberty for arbitration. On 10th of May. That was sometime.
Liberty is given to the petitioner to mention the matter for arbitration on the next date.
Obliged.
Yes, BTC.
I am for one.
Yeah, please, my lord.
Yes, Mr. Rabha.
My lord, I have the instruction. my lord.
Already got salary. my lord. Petitioner already got salary.
You got salary?
Yes.
Very good. Matter over.
Yes.
The Learned Counsel, Mr.
Isharam, on behalf of.
Your name?
S. Islam. Saidul Islam.
S. Islam.
Yes.
Mr. S. Islam, the learned counsel appears on behalf of the petitioner. Mr. S.R. Rava appears on behalf of the respondent number 2 to 6, as well as Ms. M.D. Bora appears on behalf of the state government. Mr. S.R. Rava, the learned counsel appearing on behalf of the respondent number 2 to 6 submits that the amount that the petitioner have already been disbursed his salary. Has been already disbursed his salary. So the learned counsel for the petitioner also submits that in view of the petitioner being released his salary as sought for in the instant writ petition, he does not want to press the instant writ petition. Consequently, the instant petition stands disposed of in view of the fact that the petitioner have got the reliefs as sought for.
43.
Yes, PWD. There is a direction for payment of the provisional pension. Have you got it?
No, no.
Okay, very well.
But P Nayak is appearing, he's coming.
Who?
P Nayak is appearing in this.
Who appears for the finance?
Finance I am appearing.
Provisional pension, you have no business.
No, it is the concerned my lord, employer my lord will have to pay.
Employer is?
PWD.
Okay, we'll take it as the last item of the day.
Lost my.
Forty-four.
Lordship, in this matter, we have received our instructions.
Yes, very well.
We have to file our affidavit, Lordship.
What is that?
Pardon, Lordship.
Yes. The case of the petitioner in brief is that the petitioner has been deprived of his pension in view of the order dated so and so on the ground that the petitioner herein did not complete continuous service in the transport department on or before so and so. Directed to take instruction. Yes, what is your instruction?
Lordship, my instruction is that I'm for the ASTC. ASTC have sent the papers to transport department. Transport department have rejected his claim, Lordship.
Yes, my lord. Lordship, as per the notification of 31st of March 1970, my lord. Lordship, may kindly have a look at the notification. He is not entitled for pension, my lord. Similar matter, Lordship has already issued notice, my lord. Last week, Lordship, same matter has been 1970 notification, my lord.
Mr. Counsel. Mr. Patiri, the problem is without challenging this office member, the orders of the governor dated 31st of March 2070, can you do that?
I have not challenged, but I have claiming pension in percent of the office memorandum of page 42, my lord.
Huh?
Page 42, my lord. On that basis, nowhere stated, my lord, regarding that notification, my lord.
Page 40?
42, my lord.
Yes, what does it say?
It stated, my lord,
Oh, it's different. It's a
was permanently absorbed in the, my lord, STC, my lord, is entitled to pension, my lord. Issued by the Pension and Public Defence Bureau on 30th November 2005. That issuing that this my lord, office memorandum, the transport department, STC forwarded the pension proposal. So the petitioner serving my lord 9 years, 9 months in the transport department and subsequently 25 years, 7 months in under STC, my lord.
Huh?
Under STC, my lord, he has served my lord 25 years, 7 months and 9 years, 9 months under the transport department. Up to my lord, 31st 12
So by
1976.
virtue of this 2005 office memorandum, you are entitled to.
My lord.
No, Lordship. The petitioner case is covered by the notification of 1970, my lord. He is not entitled for pension because his service tenure is less than 5 years. As per notification, this is the notification regarding the Principal Secretary, Pension and Public Grievance Department.
But
Petitioner,
first and foremost, madam, tell me whether you are a public, whether the ASTC is a public, state public undertaking. Is it? Matter any?
my lord, will file affidavit, Lordship.
File it.
My lord,
Why haven't you filed it? I've given you more than a month.
Lordship, I have received instruction, my lord.
Take this.
My lord.
Because here, if you see rule 1,
My
clause 1, says who would be entitled to.
My lord.
It does not debar the others.
Okay.
It does not debar that these person would not be entitled. It only says who would be entitled.
Okay.
Now, by this 2005, it gives the entitlement to those persons. That is the difference. Heard Mr. K. Patri, the learned counsel, appearing on behalf of the petitioner, Mr. M. P.
Lordship,
Bora.
may I point out one thing? Then point number 4 also.
Yeah.
This office memorandum, my lord. May I read, my lord? Family pension will be admissible from only one source, that is either from the state government or public sector undertaking and not from both. However, the benefit of family pension scheme will be available to only those employees who are permanent and have a qualifying service of not less than 10 years. In the
Understood, but this has been, don't you think this will be overridden by this 2005?
this is 5 notification, Lordship. I'm reading from the 5 notification.
Yes.
Then qualifying
clause,
service has to be examined, Lordship. 4,
Where?
matlab. I mean,
family pension will be admissible for only one source, that is either from the state government or public sector undertaking. However, the benefit of family pension will be available to only those employed who and have a qualifying service of less than 10 years. He has.
from state, he has mentioned 9 years in the transport.
No, not in the transit, state.
Yes,
In the, this is a, the qualifying service has to be taken in regard to state public undertaking. And he has 10 years. He's 25 years or something. Then why he is not entitled? Heard Mr. K. R. Patri, the learned counsel, appearing on behalf of the petitioner. Ms. M. D. Bora appears on behalf of the
Lordship,
transport
I am for
department.
Only one.
And Mr. Shishama appears on behalf of the AST. The learning council appearing on any finance? And then Mr. Bigogo appears on behalf of the respondent number 2 and 8. The learning council appearing on behalf of the transport department as well as the ACC submits that they would like to file an affidavit in the instant matter. Taking into account that the matter pertains to pension, family pension, and the petitioner husband,
No, my lord.
No,
The
petitioner
petitioner
is
itself.
or he himself,
My lord.
the petitioner had already retired on
On my lord,
31/7/2002.
31/7/2002. This court fixes this matter on 9th of May 2023.
My lord.
On which date an attempt shall be made to dispose of the writ petition. The respondents are given liberty to file their affidavit by 2nd of May. 2nd of May.
Lordship may kindly observe in Lordship order whether this notification is applicable to the public, whether that it will be easier for me to take it.
The learned councils appearing on behalf of the respondents in their affidavit shall clearly indicate as to whether the notification dated, office memorandum dated,
Lordship, it's page 42, my lord. 30th of November 2005, 3011
30th of November 2005
issued by the
would be
pension.
applicable to the case of the petitioner.
My lord, I'm deeply obliged. my lord. Lordship,
Basic.
may I pray for a copy of this order?
Why?
I
Take a
downloaded the-
certified copy, with the or show the vertical live streaming.
My
Yes.
obliged.
My
My
senior
lord,
is engaged in court number 7, Lordship.
But in this matter, MM Kotoki is engaged as a standing counsel, my lord. She has a bereavement in her family, my lord.
Who?
MM Kotoki, my lord. Lord, could she be accommodated for a few days, my lord?
What are you saying?
Lordship, my senior is engaged in court number 7.
It has been brought to the attention of this court that Miss MM Kotoki, the learned counsel appearing on behalf of the respondent number 1, 3, 4, and 5, is in bereavement. Taking into account the same, they let the matter be listed on 26th of April 2023.
Deeply obliged.
48,
Yes. And,
My lord, I have the instruction. That's all.
Yes,
I have the,
whether he's entitled to as per Upender,
yes, yes.
give him.
Well, like, we've actually sent the name of the petitioner along with a list of, my lord, 1080 numbers of casual workers, and it has been sent to the finance department for necessary approval. Madam.
Then
Has been sent way back on the 17th of November 2021.
those aspects I know, because he had filed a contempt. The contempt was dismissed because was closed because the finance department was not a party to the original proceeding. And I know that. Now the therefore is, as per you, because you have categorically made a stand in the contempt proceeding that look here, we are willing to give. But the problem is that finance is not giving the approval. Isn't it?
Yes.
And that is why it was closed, giving him the liberty to file a petition.
In that case, my lord, if I recall rightly, the finance department was not with a.
Absolutely. Therefore, he has now made the finance. So let us hear the finance, which creating the stumbling block.
Letters of the proposal, my lord, I can have the instruction. But my lord, Lordship may kindly turn to page 30 of the repetition. This is the letter dated 5th of January 2015. It is prior to my lord Upender. Whether there are certain queries, my lord. These three conditions are to be fulfilled because my lord, this honorable court, while my lord considering the earlier repetition, Lordship may see page 37.
So considering the entire.
After considering an entire aspect of this is disposed of at the motion stage itself, directing the respondents, more particularly the Principal Secretary Government of Assam PNRD Department, to consider the case of the petitioner for such benefit as stipulated at para 22 of the State Division Bench judgment and ordered it as so and so, subject to the condition that initial appointment of the petitioner was made in accordance with law as per the eligibility applicable at that stage. So this part will have to be clarified by them.
Why?
No, while sending the
No,
proposal.
what does Upender say? The direction is that those people who have
Who are
been
serving for 10
working
years.
out there on non-sanctioned
Sanction.
to be entitled to the minimum of pay.
But it has been added now. my lord.
No. If something is added which is not there, then deprive the
Otherwise,
petitioner.
yes, Upender. But in that case, my lord, as has been submitted by the my lord, standing council for the PNRD today, let me have instruction on what the finance has
Because
done.
what I will show here, you kindly see here, the order in the contempt proceedings. If I remember, because I remember
Page
that
52.
matter. Yes, here.
Page 52.
On 31, page 52. Have a look.
My lord.
Also heard Mr. M. Nath, the learned counsel appearing on senior counsel is appearing on behalf of sole respondent who submit. In terms with the order dated 29/11/2019 passed by this court in so, the respondents have done their part and the matter was sent to the finance department seeking necessary approval. However, the finance department have not accorded the approval, as a result of which the matter could not be processed further. From a scrutiny of the materials available on, I find that the finance was not a party in the petition, and therefore it is apparent that there was no direction upon the finance department to deal with the matter in any particular manner. There is no dispute about the fact that the respondents have carried out this part in terms with the court's order. Therefore, it cannot be said that there was a willful disobedience.
Well,
Now, what they have carried out is what?
they have forwarded, according to them, they have forwarded the name of the petitioner along with other similarly placed persons by this letter dated 17th of November 2021. Okay. So, my lord, in this regard, I can have the instruction. My lord.
See, with regard to the above, I would like to inform you that the commissioner so-and-so dated so-and-so and a clarification was submitted to the government. Additional left out 3 MB legal for consideration of the matter for payment of the enhanced fixed pay or remuneration in pursuant to the at the earliest. In terms of the contempt case number so and so. And 409, you see?
Yeah.
Kindly see page 51.
Yeah, 51, dated.
In the matter of Raju Alam are pending before the High Court in this regard. This is for your guide. Now, as per you, whether he's entitled or not.
Yes, ma'am.
Huh?
Yes, ma'am. That's why in the forwarding, in the letter, my lord, wherever we submitted the list, we picking the subject clearly, my lord.
Page?
It's there, my lord, in the page 42. of the
Page 42, my lord. My lord will have a look at the subject, my lord. Submission of list of 1080 numbers of casual workers working under the Panchayat and Rural Development Department for necessary approval for payment of minimum of max pay scale as per the Honorable Guwahati High Court's order dated so.
So the petitioner's name is there.
Yes, my lord. I have the enclosure where the name of
Show me the enclosure.
the name of the petitioner is enclosure is filed.
So the petitioner, as per Upendas, is entitled to. Now it is only the finance who have to take a call.
And then again, I'm the inspector, that is what it is. Because on the last occasion, this was the specific query of your lordship, and to the PNR department.
Because insisting on something which is not there in Upenda may not be proper. Where is his name?
My lord,
Oh
list
yeah,
5, my lord.
got it, got it.
I've given the name of the
Rabizul Iman,
Seal
date
number
of engagement
10110.
Iman, length of service till 2017 is 12 years. Scale of air, fixed pay. Whether work charge, master's air or fixed. Heard, Mr.
AMS Majumdar.
AMS Majumdar, the learned counsel appearing on behalf of the petitioner. Mr. N.K. Devnath appears on behalf of the Panchayat and Rural Development. And Mr. B. Gugoi appears on behalf of the Finance Department. Mr. N.K. Devnath, the learned counsel appearing on behalf of the Panchayat and Rural Development submits, has drawn the attention to the enclosure to Annexure 15. Wherein a list of 1080 numbers of casual workers divided into 5 categories were sent to the Finance Department for their approval for getting the minimum of the scale of pay as have been declared by the, as has been directed to be entitled to by the division bench of this court in the case of State of Assam versus Upendas in writ appeal number 45 of 2014 dated 8/6/2017. It appears that the petitioner's name
is in list number 5, my lord.
is found in list number 5
Seal number 110.
of casual workers at serial number 5 at list number 5 of the casual workers at serial number 110, wherein it has been mentioned that the date of engagement of the petitioner to be 28/2005 and the length of service till 2017 to be 12 years. And the petitioner was paid fixed pay. Taking into account the same, taking into account the stand of the Panchayat and Rural Development Department, which categorically shows that the petitioner is entitled to, in terms with the judgment of the division bench in the case of Upenda Supra, the learned counsel for the finance department is directed to obtain instruction as regards what steps have been taken for the purpose of granting the benefit of the judgment in the case of Upen Das in respect to the petition. This is the matter on 12th of May 2023, on which date the learned counsel for the finance department shall obtain the necessary instructions in that regard.
Maybe allowed to mention.
Petitioner is granted the liberty to mention the matter for upgrading. Mr. Yeah, can we keep this? I think this will be relevant. No,
I have made a copy.
you make a copy of it, huh? And give it. The instructions were placed by Mr. The instructions were placed by Mr. N.K. Debnath is kept on record and marked with the letter X. Give him a photocopy. We'll give you a
49.
photocopy. Because I think this will be very relevant later on, because he doesn't have that copy, the list. Yes. Who appears for B. Gogo appears on behalf of respondent number 3 and 7. D. Bora appears for 2 and 5. Case of, oh, this one.
My lord.
Yes.
My
Why
lord,
you are not giving him this 14 years, 7 years?
Oh, yes, my lord,
Removing-
actually, today we are supposed to produce the instruction, my lord.
Yes.
D. Bora, he took the notice, my lord. Today, my lord, I missed the file also. My lord, sometime may be granted, my lord, I will have to take the instruction on why 14 years has been deducted. But the actual facts, I don't know, my lord. That's why, my lord, some time may be required. And in the meantime, my lord, if he has received it, my lord, I will collect it.
Huh?
If the D. Bora has received the instruction, my lord, I will collect it from him.
Okay. We fixed the matter on 3rd.
Third.
Get your instructions.
Yes, sir.
Heard Mr.
M. Islam.
M. Islam, the learned counsel for the petitioner. And Mr. T.C. Suti appears on behalf of the respondent number 2 and 5.
Yes, sir.
Mr. B. Gogo appears on behalf of the respondent number 3 and 7. And Mr. N.K. Debnath, you are appearing for which department?
PNRD, madam, for respondent number
Appears
1.
on behalf of respondent number 1, 4, and 6. The Mr. T.C. Sutia, the learned counsel appearing on behalf of the Director of Pensions, submits that the instructions as sought for by the order dated 23/2023 is awaited, and he seeks an accommodation for a week so that he can apprise this court as regards the instructions so sought for by the order dated 23/2023. List the matter on 3rd of April 2023. On which date the learned counsel appearing on behalf of the Director of Pensions shall apprise this court as regards the instructions so sought for in the order dated 23/2023. Liberty is given to the petitioner to mention the matter.
54.
Highly obliged.
Yes, Mr. Bora, what are you asking for?
The simple method, the petitioner has been transferred before completion of 2 years, my lord.
And then?
That is the issue, my lord. Before completion of 2 years of service in his present place of posting, my lord. And next up is his posting order, my lord. Annexure 3 on 11/4/2022. So he has been transferred on 28/12/2022. Just after completion of about 8 months, my lord. That is the main issue, my lord.
28/12/2022.
Yes, my lord.
After how much period?
8 months, my lord. Annexure 3, page 24 is his posting order, my lord.
What is this order?
Similar case.
Similar case, order. In this case, he has been transferred within the district. First of all, second, Lordship, he is suspended from service. He was suspended from service. Now reinstatement. Thereafter, he was transferred. Lordship.
Oh,
That is
did you
the-
mention that you were suspended from
Yes.
service?
Yes, my lord, that I have mentioned, my lord.
Okay, now you have been reinstated.
Reinstated on.
You have been brought from where to where?
within the same
from,
district.
Your name is what? Professor
Professor
Kolita.
Kolita.
Yes, my lord.
Nalbari,
Revenue circle to
from where were you
From
earlier?
Nalbari Revenue Circle to the Land Acquisition Branch of Deputy Commissioner's Office, my lord.
Land acquisition branch of?
Deputy Commissioner's Office.
distance between the more less than 300 meter.
Mr. P.P. Bora, the learned counsel appearing on behalf of the petitioner, Mr. S. Datta appears on behalf of the Revenue and Disaster Management Department, Assam, and Ms. M.D. Bora appears for the state government.
It's number 2, my lord.
The instant writ petition has been filed on behalf of, it's challenging the order dated 28/12/2022, whereby the petitioner, who works as a lot mandal,
Yes.
was transferred from the Nalbari Revenue Circle to the Land Acquisition Branch of the Office of the Deputy Commissioner Nalbari Personnel Branch. Of the Office of the Deputy Commissioner Nalbari. Mr. S. Datta, the learned counsel appearing on behalf of the petitioner had submitted, on behalf of the Revenue Department had submitted that in Nalbari district, several land acquisition cases are going on. That is, number 1, GDB Road, bracket 26 cases. Number 2, Okom Mala, bracket 14 cases. Number 3, SSB. Number 4, AIDC and NESRIP. Taking into account the same, there was a necessity for transferring the services of the petitioner from the Nalbari Revenue Circle branch to the Land Acquisition Branch, which are both within the Office of the Deputy Commissioner Nalbari.
No, that is not correct, my lord. Both are separate establishments, my lord. Nalbari Revenue Circle is at a distance of about half kilometer, my lord.
Forget about the half kilometer,
No,
but
Within the
But you see, the Nalbari Revenue Circle has to be under the Office of the Deputy
Yes, my
Commissioner.
lord, that is true.
Land Acquisition Branch has to be under the Office of the Deputy Commissioner.
Deputy Commissioner.
Then what is wrong?
Establishments are different, my lord.
Taking into account the reasons stated by Mr. S. Datta on the basis of the instructions received from the Deputy Commissioner.
Yes.
And further to the effect that the petitioner's transfer is within the same establishment and the distance being only half a kilometer, this court finds no reason for interfering with the order dated 28/12/2022. Consequently, the petition stands dismissed. The instructions were produced by Mr. S. Datta. It's kept on record and marked with the letter X. The interim order passed on 4/1/2023 stands vacant.
Acknowledgement.
58,
Yes, Mr. Sharma.
Lordship, on the last occasion, in fact, on 22nd of February, Lordship, I placed an instruction
NXRX, yes.
whereby on 19th of September,
Ah.
2022, the area salary proposal was sent to the government
Yes,
by the
please,
Director of Elementary Education
I
Department.
would therefore request the government to please accord sanction.
Lordship.
Now the sanction granted.
And subsequently, from the government, there was a clarification was sought for. A white communication dated Lordship, 3rd November 2022.
And subsequently, pursuant in compliance to that clarification, the Director of Elementary Education has passed an speaking order on 10th of November 2022. And by the time this speaking order received by the government, recently there is a notification, I'm told telephonically, that is issued by the Finance Department to stop all the new sanction, to stop sanction. That I think perhaps will be clarified by my learned colleague from the Finance Department.
Yes.
So now,
Mr. Gogoi, what is this?
so now the government has, the government shall direct the Director of Elementary Education Department to submit a fresh proposal. Once the fresh proposal is received, because there is a notification, I'm told, from the Finance Department to stop now recently on 18th of.
I thought that.
No,
Maybe
no,
a general
nothing doing. We
notification.
direct you to make the payment within 30 days.
Lordship, once
Nothing
that
doing. No. What is
fresh
this
proposal
finance?
is required to be sent by the director again.
No, these are not required. Whatever you want to do, do it.
Lordship.
Everything has been done and then you are
Lordship,
not
everything has
doing
been done only because of that notification.
what notification. And this is pertaining to what? The petitioner is retired?
Petitioner is retired, only that area salary for a particular period, and that amount will be.
Pay
we will
the
be getting that
increment
amount
area
of
salary of the petitioner
3,09,000.
only for the period from 89 to 2017.
Lordship.
Then everything has been done and now these people have, the finance have done all these things.
Because of the order of 18th March, that amount could not be sanctioned, I am told, and then they shall direct the Director of Elementary Education Department to furnish a fresh proposal.
Heard Mr. A. Rustic, the learned counsel appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of the Elementary Education Department. And Mr. S.R. Burwa appears on behalf of the Director of Pension. The instant writ petition has been filed by the petitioner claiming the area salary of an amount of rupees 3,09,069 for the period from 1/1/1989 to 30/9/2017. It appears on record that the said writ petition. Mr. Counsel, tell me how the writ petition has been filed on the basis of a certificate?
Annexure 1 is the order by which we are calculated.
Huh?
Annexure 1.
No. What is your page 10?
Oh, at the time there was a lockdown. Lockdown period, the petitioner could not come.
Okay.
That is a military practice.
The said writ petition was filed on 21st of September 2021. In the meantime, while the matter was taken up earlier, on 22/2/2023, the learned counsel appearing on behalf of the Elementary Education Department have placed on record various documents which categorically shows that the petitioner is entitled to the amount of rupees 3,09,069, which is the area salary for the period from 1/1/1989 to 30/9/2017. There is no quarrel. It being an admitted fact that the petitioner is entitled to the said amount. Yeah. Today, Mr. P.N. Sharma, the learned counsel appearing on behalf of the elementary education department, submits that on account of some instructions received from the finance department, the elementary education department have been further directed to reprocess the claim of the petitioner. It surprises this court that when the authorities concerned have categorically held that the petitioner is entitled to the amount of rupees 3,09,069 by the order dated 10/11/2022. Why the said have not been paid to the petitioner? Considering the non-payment of the said salary, area salary of the petitioner, in spite of holding that the petitioner is entitled to. Are actions which are unfair and unreasonable, and therefore violates the mandate of Article 14 of the Constitution. The petitioner had retired on
39/2017. 39/2017.
39/2017. And he has been made to run from pillar to post to get his area salary for the period
on 59 to 39.
to get his area salary since the date of his joining till the date he had retired.
The difference amount.
Huh?
No, this is the difference amount of that basic amount. Not the entire salary for the period. The difference
has been-
salary, there is a
He had been
one sanction was
had
there,
to
no,
run
that was
from
not-
pillar to post for getting the
one increment.
increment.
There are three
Of the increment, which have resulted in the area salary of the petitioner for the period from 1/1/1987 to 30/9/2017.
59.
Considering the above, how much interest? 15,
Because
20,
may I clarify one point. That
15%?
finance department instruction is not to send the fresh proposal. There is a notification from the finance department whereby new sanction has been stopped for now, time being. So as a result, the commissioner, the secretary of the education department shall direct the director to submit a fresh proposal, thereby they will. sanction
Proposal
the
means
amount.
again it will take
So
some
there is
time.
no instruction from the finance department asking for furnishing the fresh proposal.
Not to send.
Not new sanction has been stopped. Now new financial sanction has been
Like
stopped by the
they had submitted that
notification.
there is a finance. Finance department কি লিখলে?
Fresh sanction has been stopped.
No, তার আগত। No, আগত। Mr. P.N. Sharma had submitted that reprocess the claim of the petitioner.
That direction was not from the finance department. Finance department has issued a notification whereby new sanction has been stopped now for the time being.
By which had submitted that in view of some notification issued by the finance department, the process of sanction of the petitioner have been stalled.
In general,
Have been stalled.
new sanction to any amount, in
Sanction
general,
of-
has been stopped.
তলত লেখো, এটা কি দেখিলে এইখিনি? The increment. Increment. Boleh? Boleh. Nine. Go. A period of almost 6 years have gone by. And the petitioner still remains at the mercy of the respondent authorities to get the increment to which the petitioner is otherwise entitled to. Considering the above, this court fixes this matter on 3rd of May 2023. On the same date, the Learned Counsel appearing on behalf of the Elementary Education Department shall apprise this court as to whether the amount has been disbursed to the petitioner or not. This court further puts the officials of the Elementary Education Department at notice as to why interest at the rate of 15%, 18% per annum should not be imposed upon the Elementary Education Department for delay in disbursal of the area salary of the petitioner. Since the year 2017. This court further puts the said department, the officials of the department to the notice that why on the return next date, this court should not impose such interest as mentioned here in above upon the Elementary Education Department, which the said department shall recover from the salary of the erring officials.
My lord, I could not.
List the matter, liberty is given to the petitioner to mention the matter.
My lord, I don't know if this lordship, I could not mention at 10:35, but it was my lord mentioning hour it was over lordship. And due to my lord traffic jam, I could not reach at 8:30. Item 56, my lord. Only my lord, small correction is there. Right?
What 56?
Item 56.
No, wait, I'm not finished it. It will last item to kiban.
43.
Then I'm taking up matter. Why you're mentioning it? You wait till 5:30, we'll get your chance. Yes, PWD. We are Peter and finance will apprise you whether the directions the order details has been complied with. Ooh. Yes, Mr. Naik.
Yes, Lordship, so far my instruction is concerned, Lordship, on 17.3, Lordship, the concerned executive engineer has forwarded a proposal to the government, Lordship. Presently, it is under the consideration of in the office of the chief engineer. It will be forwarded to the accountant general for its approval immediately.
For provisional.
For provisional pension.
Then when
Pension
should we have
paper
it?
will also be prepared simultaneously.
Where is the accountant general? None appears.
No, it is not yet forwarded to them, Lordship.
Then why haven't you forwarded it?
No, Lordship, it was received only on 17.3. It will be done, Lord.
Understood, but you see the petitioner have retired on 31/7.
21.
31/7/2021.
Yes.
I'm not saying about the regular pension. I'm saying about the provisional pension. Isn't it the necessity of your law
Yes.
that he should get it immediately?
No, why?
And if it takes 2 years for provisional pension, what about this? Why don't you ask your state government to change the rules of 1969 or the year to that effect, or even the pay, ROP also? Ask them to change it and say that the person who is about to retire stop his salary for the last 1 year, so that he gets accustomed to the fact that the pension is going to be delayed. Something needs to be done. This is of 2021. That is the mandate of your office memorandum. The rule 22 categorically mentioned that you have to give it. Then also, we hear that on 17.3 it has been sent. How is the person going to survive? Tell me, Mr. Naik. A person who have retired, how is this going to survive? When should we take it up?
Lordship will pick up this matter after 3 weeks, Lordship.
No. This is a compliance to the order dated 6/2.
Yes, it has
Then-
it is in the process of
No,
compliance.
it is not process business out there. We'll take it up a third. You inform this court what has happened. This is provisional pension.
Lord.
I'm not on the main pension. I'm not talking about. This is provisional pension. And if they have not worked out that, ask them to do whatever is necessary. Send it by special messenger. It's not. Otherwise, this would be we'll hold them these people as contempt. Who is that officer?
Lordship, it has been forwarded to the additional chief engineer planning, Lord. And it
name?
was forwarded on 17.3.
Heard Mr. J. Losko, the learned counsel, appearing on behalf of the petitioner. Mr. P. Naik appears on behalf of the PWD department as well as the finance department. And Mr. C. Sharma appears for the NC, for the Dimahasa Autonomous Hills, Autonomous Council. No accountant general. Yes, Miss, what's your name? Jdas? He appears on behalf of the accountant general. And Mr. T.C. Sutia, you appear for the director of pension? Earlier, Mr. S.S. Roy was appearing.
Yes, there's a letter attached to our. We have the honor to copy data test, so it's not related to the director of pension. It's good, but.
Because this PWD will go directly to them, no? Okay. This court, by the order dated 6/2/2023, had directed that a provisional pension and other benefits as mentioned in the notification dated 21/6/2012 issued to the petitioner, be granted, be disbursed to the petitioner forthwith. Gusto. It appears on record that on 31/7/2021, the petitioner had retired. And even after a passage of more than 1.5 years, the petitioner is yet to receive the provisional pension, as well as the DCRG. Mr. P. Nayak, the Learned Counsel, on 23/2023, when the matter was listed, there was no instructions forthcoming from either the PWD department or the finance department in that regard. Today, Mr. P. Nayak, the Learned Counsel, appearing on behalf of the PWD department, has submitted that the proposal has been sent on 17/3/2023 to
The additional chief engineer planning PWD.
additional chief engineer planning PWD
Road.
for the purpose of
Both for provisional pension as well as for pension.
provisional pension as well as for pension. A perusal of Rule 22 of the rules of the Assam Services Pension Rules 1969, as well as the Office Memorandum dated 21/6, notification dated 21/6/2012, makes it clear that a pension that an employee upon retiring is to be immediately paid the provisional pension, as well as the DCRG, if there is no departmental proceedings pending against him. In the instant case, on 31/7/2021, the petitioner had retired. This court, by the order dated 6/2/2023, had specifically directed that the provisional pension as well as the DCRG be paid to the petitioner, and the provisional pension and other benefits, as mentioned in the notification dated 21/6/2012, be paid to the petitioner forthwith. However, in spite of that, the respondent authorities are taking their time are taking their sweet time. And it was only on 17/3/2023 the proposal has been sent for provisional pension along with the regular pension. This court fixes this matter on 3rd of April 2023. On such state, the Learned Counsel, appearing on behalf of the PWD department, shall apprise this court as to whether the order dated 6/2/2023 have been complied with or not. Failing which, this court would have no other option but to direct personal attendance of the Commissioner and Secretary to the Government of Assam PWD Department for necessary compliance.
Lord, we will do our part, Lord.
I am not concerned with that. Provisional
Subject to
pension
approval
has
by
to
the
be paid.
Accountant General, Lord.
No, this is absolute non-compliant. You want, I can ask him
Item
to
10.
appear now.
Lord, some confusion here, dear Lord.
No, there is no question of any
From
confusion. There is a
2015.
direction given. Why have you moved the matter only on 17.3?
Lord, on last date, Lord, my.
I'm not directing now for presence. I'm mostly asking whether there has been compliance on next date.
2015 to 2021, he was under suspension. And just before 2 months. prior to
Whatever
his
may
retirement,
be,
Lord.
the provisional pension has to be paid. That is the law. The provisional has to, if he has been in suspension, you are going to make the final PPO whenever you like. That is another aspect. But I'm only concerned about this. Yes, item number?
My lord, petitioner case, my lord, he was my temporary engaged, my lord, laboratory assistant.
Now, why is this matter? No. Itu kiman number item? Okay. Yes, what do you want?
My lord, page 10, my lord, by this order, my lord, petitioner was engaged as laboratory assistant, my lord. On
His
fixed pay, my lord,
salary for
5,000 per
24
month.
months, that is from April to
And
March,
my
shall
lord,
not be paid with interest.
my
You have
lord,
not got your money?
No, my lord.
Which department?
24, my lord, Assam University Silchar, my.
UGC,
Yes,
Finance, Assam University, Silchar.
my
Have the service been made?
lord, yes. My lord,
Affidavit by respondent number 5.
my lord, respondent number 5, my lord, we took my lord, register step, my lord, thereafter, trustee service also, still my lord is not prepared.
In view of that, the service of notice upon respondent number 5 is treated to be completed. SK Chauhan. Now, who is appearing for the this Assam University?
My lord, earlier, my lord, Shankar.
Who has appeared?
Correspondent number 2, Shankar Debroy appear, my lord. And one.
Wait, A. Samoa, the Learned Counsel for UGC has accepted notice on behalf of respondent number 134
Yes.
and 2. Means 1, 2, 3, 4.
Yes.
Okay.
So my lord, his fixed pay.
Who appears? How can the Union of India be represented by him if he is not a Union of India Council? Any Union of India? None. Chalo. Okay, heard Mr. S.K. Chauhan, the Learned Counsel appearing on behalf of the petitioner. None appears on behalf of the respondent on call. List the matter on May 12th, 2023. It is made clear that if the respondents are not represented on the next occasion, this court shall proceed with the matter. In their absence.
11.
These are all options. By this repetition, my lord, we are praying for pay parity of home guards deployed in the DIPCO. My lord, we are being paid our wages, my lord, as per the my lord, the advanced rate given by the government of Assam. However, my lord, our counterparts who are working from the states of Meghalaya and others, they are getting much higher salary, much higher wages, my lord, for the same work that we are doing. My lord, in fact, the Central my lord, Labor Commission has also
Pay parity.
Pay parity. This, we are not getting paid as per the Central Labor.
Who wants how much money?
My lord, we are paid at the time of filing the writ petition monthly 10,500 for a 30-day month. My
So
lord.
everybody wants money or only one?
No, my lord, 60.
Okay. Mr. P. Nayak, PD Nayak, the Learned Counsel appearing on behalf of the petitioner and
SOD for respondent number 6 and 7.
SOD appears on behalf of the respondent number 6 and 7. None appears on behalf of the respondent number 1, 2, 3, 4, 5, 8, 9, and 10. Full stop. It appears that there are 60 petitioners claiming
I am representing my lord.
pay parity. You can't represent for everybody. Finance, how can you appear?
Response number 1, Government of Assam Political Home Trust.
Pay parity, claiming pay parity. Which though, although the claim may be similar, but the cause of action is separate and distinct. However, it appears that only the court fee of only one petitioner have been paid. Considering the above, let the matter be listed again on 15th of May 2023. In the meantime, the Learned Council, the petitioner is directed to pay the deficit court fee.
Deep down.
13.
Oh, yes, Mr. Doctor. Why did you ask for the liberty?
My lord, I have received the salary, present salary.
Hmm.
And
Area salary occurred during the suspension period, you have got it.
Yes.
And if any, and also present monthly salary from June, you have got it?
Got, my lord, but the area salary during the pendency, okay, during the suspension period, not.
No, you have not got the suspension period.
Yes, my lord. Not
24, 2015 to 6/6/2018, have you got it?
Not received, my lord.
So
My
my
lord,
instruction is that it has the area salary has been given, your lordship. That's my instruction, your lordship.
You have it?
Lordship, it was a verbal instruction, your lordship.
Then I have
And
initiated an DP and paid the service continuity to bring the service continuity.
So how can you withdraw?
Because I have to amend it to bring initiate an DP and pay my area salary to bring the service continue to regularize the period of suspension, my lord.
Lordship,
And as per
that
ROP
his
rule
period was
2007.
regularized, and that's why the area salary has been given, your lordship. Lordship, maybe tomorrow, maybe day after tomorrow, I'll bring the instruction, your lordship.
Let the matter be listed on Wednesday.
Lordship. Apply for it.
On which date Ms. D. Busari, the Learned Council appearing on behalf of secondary education,
Lordship, second.
shall apprise this court as to whether the area salary of the petitioner have been paid for the suspension period.
Obliged, your lord.
14.
Liberty is given to the petitioner to mention the matter for appellate. Yes. Any instruction?
No, lordship, perhaps this irregular and illegal appointments, perhaps lordship, they are claiming salary for from April 2012 to 2018, when that petitioner has retired, lord. So lordship, singular matter, your lordship has fixed on 10th of April, lordship.
10th of April.
10th of April.
List the matter on 10th of April 2023. Mr. P. N. Sharma appears on behalf of the elementary.
Elementary, lord.
15 and 16.
There, please, lordship. This matter
Yes,
is-
Mr. Khan.
This matter is pertaining to pension of the petitioner, lordship.
Huh? What?
Relating to non-payment of pension, lordship.
Non-payment of pension.
Pension, lordship.
Why are both matters together?
But I don't know my friend's case. My friend is saying that his case is different.
So obviously, this shouldn't be both together. Both are different.
Yeah.
Anyway, so what is it?
My lord, during the service period, my lord,
Which is 4107, which your matter?
my matter is
Your matter. Okay, any instructions, Mr. Sharma?
Lordship, this matter, 9536/2019 Lordship, that the petitioner is claiming pension as per 1969 rule. The OBB teachers, the Lordship.
Oh, this one?
Lordship, 9536 of 2000.
9536 is OBB.
Lobby, Lordship,
7066.
Lordship.
You come within the 7066 or 4040.
my case is something different.
Then there is no OBB.
My lord.
There's only two OBB.
Why?
Either you have to come under 7066 or 4040.
Okay.
Or it's a case of illegal appointment.
Illegal.
This is nothing. And in the morning, I have dismissed one matter. You were there?
No.
No.
Mr. Khatun.
Yeah.
Lordship, fix some of the day, Lordship.
My case is something different.
No, then OBB. Are you OBB?
No, initial lordship.
No, OBB has only two schemes.
My lord.
Matter in. And what about 4107? Anything?
Yes, my lord.
Lordship, 4107, admittedly, Lordship, the petition has been instituted after attaining the age of superannuation of the petitioner. Lordship.
What is he asking for? That is why it was made returnable
Now,
after 8
Lordship, the
weeks.
only remedy available is maybe, if at all they are eligible, then there will be
Pay
by way of
adequate
compensation.
compensation to the petitioner along with the service benefit. Rate should not be issued directing the respondent people to consider the representation. Any other relief. Now, what are you asking, Mr. Counsel?
Yeah, my lord, in this case, my lord, we have been appointed, my lord, in the year of 1998, my lord, the sanction post, my lord. After the service book opened and the GPF account.
Sanction
opened,
post on the what?
LP school, my lord, assistant teacher, my lord.
Pursuant to which appointment?
My lord, lordship will get, my lord, the honorable court's order at Annexure 1, my lord, page 26.
And now what do you want? You have filed a petition.
Lordship will find, my lord, directly.
You have filed a petition in when you have attained the age of 64.
Lordship, can you have a look on page 54, my lord?
No,
Annexure
what do
6.
you want?
My lord, for the since 2004 to my lord, to 2021, my lord, they have 4 reports issued in our favor, my lord, for so far as our appointment is concerned, my lord. But by that time, we got crossed the age limits, my lord. And among them, my lord, one person, my lord, of the petitioner who approached earlier this court, my lord, they got appointment, my lord, but we could not get appointment because of attending of superannuation, my lord. So in this case, my lord, on lastly, my lord, lordship will find at page 68 and Annexure 14, my lord. We made an application, detailed application.
What
my
is
lord.
page 67?
Yes, my lord. 67 the appointment. The similarly placed, my lord, who was the petitioner with us, my lord.
You have got an appointment like this?
No, my lord. She got appointment, my lord. She was one of the candidate, my lord, who contested for this court.
So you don't come even within the ambit of irregular also.
And my lord, she got appointment, my lord, but we by that time we crossed the superannuation period, my lord. So therefore, my lord, we made an application. They are not denying, my lord. Since 2004 to 2021.
Mr. Counsel, why don't you file a civil suit? File a civil suit.
That may pray, my lord, with some observation so that we could go, my lord.
Why do you need an observation?
My lord, the civil court will ask, my lord, then why you come so late, then like this, my lord. So with some observation,
Understood.
lordship may dispose of the matter, some observation so that we approach before the appropriate forum, my lord.
No. First and foremost, one thing.
Yes, my lord.
You approached this court in 2022.
My lord. Yes.
You were entitled to compensation when?
Yes, that's
when?
After, my lord, getting the appointment, my lord, that
when?
21.
21.
Yes.
So you have time. But you need a limitation. No case.
Civil court, my lord,
Civil court is much easier to explain.
my lord, one submission, my lord. Under similar situation, my lord, earlier on, my lord, this honorable court has directed, my lord, to approach before a civil forum, my lord, certain observation made, my lord. My humble submission, there is no dispute, my lord. Since 2004, they have initiated, from 2004.
Whatever may be, there is, you are complaining of some illegalities. What they have done is they have given you an appointment
My lord.
after you have worked out there, but you have not been paid some salary or anything to that effect. Have you been paid a salary?
Yes, within that period, 6 years, we received.
You
salary.
got salary till 2006 or 7?
2004, my lord.
2004.
2004.
You were not lucky to get the another 2 years, but most of them have got it. So 2006, and thereafter
Thereafter, my lord, since they have initiated.
you have been fighting.
my lord.
Nothing is
my
happening.
lord. By
So
that time,
better
we have
off.
crossed our legs, my lord.
Well, so you better file a civil suit. No case.
Okay, then I don't.
No,
Better-
if you are asking for compensation, go to the civil court. Issue them a section 8
Yes, my lord.
or this representation which is being submitted, treat it as a section 80 notice.
Lord, page 68 and except 14.
Huh?
Representation.
I say that you will withdraw with the liberty to approach
Yes,
the
my lord.
civil court,
Yes, my lord.
and the withdrawal of the writ petition shall not affect you for the purpose of shall not affect or prejudice your rights in the civil court.
Absolutely.
Out Mr. P.K. Dekka, the learned counsel appearing on behalf of the petitioner. Mr. P.N. Sharma, the learned counsel appears on behalf of the Elementary Education Department. The learned counsel appearing on behalf of the petitioner submits that the instant writ petition has been filed seeking adequate compensation to the petitioners along with their service benefits due to them. The learned counsel submits that the question of compensation as well as the benefits would entail would require adjudication of facts. And as such, the learned counsel submits that instead of pursuing the remedy herein by way of a writ petition, the petitioner may be permitted to avail such remedy available under law, like a civil suit. He, however, submits that his representation dated 24/1/2022, so submitted to the authorities, be taken as a notice under section 80 of the CPC, so that the petitioner need not again issue any further notice. Taking into account the said submission, the instant petition this court permits the petitioner to withdraw the instant writ petition with a liberty to approach the appropriate forum, like the civil court, the appropriate forum, wherein adjudication of facts is permissible. And the withdrawal of the instant writ petition shall not prejudice the rights of the petition. In the said, while approaching the appropriate forum, it is further observed that the representation dated 24/1/2022 be construed to be a notice in terms with section 80 of the Code of Civil Procedure 1908, and on the basis of which the petitioner can institute a suit if so advised.
If the petitioner appointment lordship subsequently, that is in terms of division bench judgment lordship, that was I have given on the last day, Lordship.
Okay, we'll take this matter up. I'm delivering the judgment very soon, this week only. Will the matter be listed after 2 weeks? Huh? 9:50. Yes, any urgent matters?
My Lord, date may be given.
Why?
This was not.
No. Okay, you have, don't have everything.
He retired from service. My Lord, item number. Lordship,
18.
another item.
Yes, you tell me, what is your thing?
My Lord, item 56, my Lord.
Item 56.
Yes, my Lord. Only small correction is there, Lordship. I have
Just
filed
1 minute. Item 56, let me see, there is some correction he's asking. In the morning, there was some mention of some correction. I have done it.
My Lord, the designation of the petitioner number 4, Lordship, should be
Huh?
subject. Designation of the petitioner number 4, Lordship.
Where?
Page 12, Lordship.
Huh?
Page 12.
Page 12.
Mukesh Bosumutari.
Assistant teacher.
Lordship, he should be Lordship subject teacher in place of assistant teacher.
Mr. Counsel, I can't do anything with this. This is not my mistake.
Yes, my Lord, this is the, my Lord, in the first title, my Lord, it's
In the cause title, you have done that mistake there while typing out. Then, how can I help you? Tell me.
Man, it is wrongly typed, my Lord.
No, not wrongly. The main petition. This is not my mistake.
Yes, Lordship.
Then,
Therefore, Lordship, I have preferred the IL.
2020.
you should be careful when you are doing it.
Yes.
What is his name?
Mukesh Bosumutari.
Number?
4, Lordship. In the
Here also, petition, it is assistant teacher.
Lordship, they kindly say.
In your writ petition.
Yes, Lordship.
Then how can I do it?
Lordship, they kindly see his appointment, Lordship. Page 18,
I'm not concerned with all these things then, but why you have done it in your petition? You have done all this mistake.
Lordship.
That is why everything has happened.
Yes, my Lord. My Lord, page 18, his appointment letter is, I have attached, Lordship. His subject is
Education department, secondary education. Yes, madam, tell me, how can this be done? Is he a subject teacher or assistant teacher? But you should notice,
Lordship.
you can't correct it because
Lordship,
this
in
is
that-
not within the purview of mine. Your writ petition, you have made the mistake.
Lordship.
And therefore this has happened.
Sorry, my Lord. My Lord.
No, sorry, wouldn't help you. Now, whether he is a subject teacher or assistant teacher, that has to be inquired because should this court give you a declaration?
Lordship, I have annexed
The moment I say that you are actually a subject teacher, but you are otherwise an assistant teacher, it would be wrong. So we'll have to issue notice.
Lordship, I have
Heard, Mr.
Yes,
S. Ali, the learned counsel appearing on behalf of the petitioner. Ms. D. Musari appears on behalf of the Secondary Education Department, and Mr. P. Nayak is there somewhere? No department, no BTC. Issue notice. None appears on behalf of the BTC. Issue notice, making it returnable on 28th of April 2023. The petitioner is directed to serve extra copies of the instant petition to the Standing Council of the Secondary Education Department as well as the Standing Council of the BTC within 3 days. The learned council, Standing Council for the council appearing on behalf of. Madam, you don't have role, no? This assistant teacher, you can't find out. Can you find out whether it is assistant or subject?
Lordship, I can get an
Okay.
instruction.
The learned council appearing on behalf of the Secondary Education Department shall apprise the court on the next date as to whether the petitioner is the applicant is a assistant teacher or the subject teacher. in which. Anything more?
My lord, item number 59 and 60 lordship.
What is that?
My lord, I want to withdraw the item number 59 lordship and 60 maybe lordship maybe taken any other date. Because this is a similar case lordship.
With what is this with two matters?
My lord, in fact lordship, the certified copy and the water matter was not listed for.
Oh, that matter. Show me that 5960. You got it?
My lord, subsequently, this matter was listed on Friday for delivery of order for IA lordship. That IA has been listed.
You have got it?
My lord. So 59 maybe we don't.
No, I cannot.
Because of wrong mention by
I was rejected.
My lord, I'm not maintainable. That was for correction of interim order. Lord.
Huh?
That was for correction of the interim order.
What is the correction you sought for?
But some one sentence was shared. Correction was your lordship with the IA that in case 10 lordship is the petitioner is presently receiving family pension. In fact, he was not receiving family pension. But sentence of lordship recorded that petitioner was receiving family pension. And secondly, lordship last operative part also that petitioner is not yet been paid partly the family pension.
Only paragraph 3. The claim of the petitioner herein is that the respondent in the education and the pension should make a fresh assessment for fixation of the correct pension, family pension, as well as the quantum of rent of the late husband for the purpose of payment of the family pension to her, considering the relevant provisions of So Act as well as to. Now, what did you ask for?
In the main repetition may be taken up lordship item number 60. Item number 60 lordship, that main repetition that may be taken up for consideration.
Show me that.
So far item 59 that may be lordship I have allowed to do.
Yes, what is your claim? Let's see.
For correct fixation of correct family pension. Because service period of the petitioner husband
Be
lordship.
not to directing the respondent to
certain
make a fresh assessment for correction, correct fixation of pension, family pension, as well as the security of on the basis of the relevant provisions of law, by taking into account the husband's service period from Iman, that is the date of Granti, receiving Granti need, and the release of the area to and so. Then the family pension effect and for a bit surgery because should like setting aside the thing of all the two letters. Then any instruction? You are looking for who?
Respond number 2 in item 59, my lord.
So his role is over.
My role is over, my lord.
Hello. We'll have this matter. This is the matter on Kali. We'll have it on Wednesday.
Item number 33, my lord.
Item number 59 that we
Good. We'll take it up on
Item number
Wednesday.
33, my lord.
Oh, Friday. Let us have it on Friday.
But I have a next one.
Item number 59 and 60 on
33.
Friday. Yeah?
33, item number 33, my lord.
Yes.
I have annexed one similar order, my lord, from this honorable, by this honorable court, my lord. I have annexed here. He is not receiving any family pension, my lord, with effect from 2013.
Item.
Next week, my lord, subject to lordship on or any date, my lord, before P2, my lord.
Item 19, my matters 2021 has been wrongly tagged because of an order passed in 19. Mine is a bench 4 matter.
What matter?
Lord, item number 20 and 21. Lord, there is a mention in the order.
What are these matters?
Lord, these are railway matters, my lords.
19 I am appearing, my lord, for the petitioner. That has been wrongly tagged, my lord, item number 20 and 21.
Wrong mention of a writ petition.
It has been submitted by Mr. K. D. Kolita,
D. Gulita, my lord.
Mr. D. Kolita, as well as by Mr. R. Dubey, that there is no connection between WPC number 891/2021 with WPC number 4500/2021 and WPC number 4506/2020. Consequently, WPC number 4500/2021 and WPC number 4506/2021 are detagged from WPC number 891/2000.
Lordship, in item number 19, Lordship, I'm respondent, Lordship. Here, item number 35 and 39, Lordship, similar matter. May take together, Lord.
It's all because of the similar matter.
Your lordship, item number 41, your lordship, matter relates to date-come retirement gratuity and other benefits since 2014, your lordship, non-payment of date-come.
Okay, we'll have it on Friday.
Friday.
Friday, liberty to mention.
Your lordship,
Item number 37.